Hey everyone. I just wanted to jump on before this video real quick. Got my pajamas on, my Looney Tunes. Probably haven't brushed my hair in a week, but that's okay because this is important and y'all don't care anyways. This is one of the worst child custody, divorce, whatever you want to label it as, family court hearings I think I have ever watched. It is incredibly triggering. So if you have a history with a domestic abuse situation that triggers you, please turn it off now. It is hard to watch. And it's not necessarily because of any violent incidents that are described, because that's not it at all. It's the behavior that reminds you so much of what you have experienced, because it's so textbook. And it absolutely breaks my heart because so many people are going through it and don't even realize they're going through it because the gaslighting and the brainwashing, and you lose who you are and you forget your purpose on this earth because you're so deep in this hole of despair and lack of self-worth. So I'm going to show it from my perspective. I know it's been shown elsewhere, but we also want to tell you that Ziggy is okay despite his run-in with the big boys. He is not a big boy. No, big boys can hurt, huh? He did have some bite marks on him, but they weren't bad. He is all good, and I want to sincerely thank everyone that helped us with our fence fund. If you don't know what happened, I'll put a link up. You can read it. I can't retell the story. It was pretty traumatic, but we had a invader that attacked the babies, and yeah, they're still pretty shook up. Every time the wind blows, they freak out and they can't be out of my sight, but they're at least physically okay, and that's what matters. So on with the show.
I hope you die. Like, let's be honest here. We hate each other. If one of us just coincidentally happened to get in a car accident and be taken off the face of the planet, and the court never had to deal with our bullshit again, it would benefit everyone greatly. Now, since I'm involved in that equation, and I kind of don't hope that I die myself. Like, obviously, I'm gonna hope you die, as I'm sure you hope I die, because then it would just you'd get full custody. Like, it would solve all of our problems.
All right. Okay, this is case number 2110643DS, Boyd versus Tilly. Today's date is December 7th, 2023. This is date and time set for our multi-day hearing on all child-related issues. Mr. Santilli, you're top left to me. If you just state your name for the record, please.
Kyle Santilli.
Mr. Tilly.
John W. Tilley, attorney for the defendant.
And Ms. Boyd.
Sarah Boyd.
Thank you. A couple of things we discussed off the record, but I wanted to go over on the record just so that they're stated. Number one, there was a custody evaluation completed. My understanding, and we can get to this once the parties start to present proofs, is that they're going to have it admitted, and we will be speaking with the psychologist. Number two, on August 18th, 2023, Judge Kromkowski issued a protective order protecting certain discovery on all health and or medical information. I discussed with the parties, and I'm going to allow them to put any argument or state their positions on the record on this order. I understand the order, but my understanding is that this does not preclude testimony on certain issues during a trial. I believe that I'm under a directive from the Michigan Supreme Court to publish this case on YouTube because of the fact that we're running it through Zoom. I don't believe that this protective order relates at all to any testimony, but I certainly don't want to be violating the order. And I wanted to check with the parties to see their position, because from my perspective, what I'm trying to avoid is running, this is scheduled for 3 days. I don't want to run a 3-day hearing and then have an objection stating that the referee should not have had this information on YouTube because of the protective order. My sort of legal finding, I suppose, is that the protective order doesn't apply to the testimony that we're likely to hear during an evidentiary hearing. I have advised the parties that, consistent with all of my hearings, I'm always willing to close the proceedings from YouTube based on MCR 8.116D1 if there are, privacy issues for the child and health and privacy issues for the parties. Because we do screen shares and things like that, and that's not for YouTube. Those aren't even things that, if you're in a courtroom, people would see, because people hand them to the witness, they hand them to the referee or judge, or the attorneys have them. So this isn't something that people just pass documents around in a courtroom. So I close it, and I believe that's consistent with the court rule. But I'm speaking generally to this protective order that was entered in this custody case, and I don't want to be violating it, of course. And I don't want to have to. What I was getting at is I don't want to have to do a 3-day hearing, and then there's an objection, and then we have to do all this over again simply because there's a position that wasn't stated earlier about whether I can proceed on the protective order. And if there's an objection to proceeding that way, I will obviously be asking the parties to file something for a decision from Judge Gronkowski, because she entered the order, and it's not my order, and I don't have any. It's something that you all will need. So, Ms. Boyd, you're our plaintiff. Any position on that decision, I suppose?
No, Your Honor, I don't object to the proceedings being live streamed in the procedure the court normally takes.
Thank you. And you're aware, and I'll ask Mr. Tilley, of course, the same thing on behalf of his client, but you're aware that if there's something that you believe we should keep between ourselves, it'll still be I never turn off the DCR recording, and as you've noticed, I record through Zoom too, just to have a backup. You just let me know, and I'll consider it and make that finding. Okay. Mr. Tilley, any position from you and your client on the protective order specifically?
No, really not. Thank you.
Okay, thank you. So that's how we'll proceed. I appreciate you all your input on that. The other thing about trial procedure, just because we've had a couple hearings, show cause hearings that are a little different format. We're just going to proceed with typical 13th Circuit Court referee trial procedure, which is I'm going to give you an opportunity to make opening statements, and then of course we'll proceed there through. We'll start with Ms. Boyd as our plaintiff to present evidence and so forth, and then once she rests, Mr. Tilley will have an opportunity to present evidence on behalf of his client, or present the case. I got his case. Just to be clear, that means that opening statements, I'm not swearing in the parties immediately. You're going to have to call yourselves as a witness. You have the right not to testify, so unless you're called as a witness. So I'm not going to just swear you both in immediately. If you want to present evidence under oath, you have to either call yourself as a witness or let me know. Otherwise, I'll swear you in. We'll move on. But we're that's how I'm going to handle it, and I want that on the record. The last thing that I have is I'm hoping that we can be civil. We've had some issues in I've had 3 show cause hearings with you all. Okay, so we're here. I'm just asking you to know your audience, for better or for worse. That audience for these underlying issues here, that's me. I'm the assigned referee. I want you all to be civil with each other. This is expected all the time, but I'm hopeful that we can be that way throughout these proceedings. I don't see any reason why we can't. The issues presented that you're presenting today, while there are some issues related to show cause and or another pending motion, and I'm going to let Ms. Boyd speak to that in a little bit on an ex parte motion, but where what you're trying to do is have me consider the minor's best interests, okay? And that's what I'm here for. So just you need to know that there's no sense in the two of you going at each other and fighting with each other, because you have to understand that that's part of what I'm observing. That's part of what one of the best interest factors, at least one, I should say at least several, relate to how you treat each other and how you behave. And that includes how you're behaving during court. So I expect you to be civil. And just remember, the point of that is how you behave reflects on you. Okay. So that doesn't reflect on me. I just like a civil proceeding. You want me, well, you want the referee, I should say. I'm not suggesting you chose me. I'm assigned the case. The point is, you want to present your evidence and I'm going to decide it. Okay. That's what we're here for. That's how we're going to cover it. I just would admonish everybody to let's try to focus on keeping it civil so that we can turn over the evidence to me and I'll decide it, and then you can go from there. Okay. I think you're all capable of doing that, but I feel the need, because of our experience together, to state that on the record. Now, let's cover, Ms. Boyd, you did bring up another issue. If you wanted to go over that on the record, I'm happy to address that. And I think that Mr. Tilley may have one as well. They're related, of course, but I want to make sure that you all can make the record you want. Okay. So we'll start with you.
In chambers, I had just inquired with the court regarding the status of a denied ex parte motion to suspend defendant's parenting time. I believe the denied ex parte motion to suspend parenting time that was filed earlier this year, I want to say late January, early February, is actually set for hearing today and is part of these proceedings. I understand the court's position on that is that there won't be a ruling today as to the suspension of parenting time, and that, the court will take all evidence and make a decision at the end of the trial.
If I may, though, I'll inquire a little bit so I can give you the opportunity to put what I believe was your position. You'd like for me to decide that issue today, is that correct?
Yes, Your Honor.
Okay. I know we talked about whether I was going to, but I want you to have, so if you file an objection, you've put your position on the record. That was the opportunity.
Thank you.
So my understanding is from the filings and the way I believe I've been directed by Judge Kromkowski is to handle all child related issues. A denied ex parte motion, if it's denied ex parte, the way I view the 13th Circuit Court's position is, once it's denied ex parte, it is scheduled like a normal motion to be heard by the court, and that's unless we're finished today. It's not something I'll be considering until we're finished, because I believe it's, I don't know if lumped in is the right word, but it's combined with everything, because the decision is more of directing me to consider all evidence presented. That's the way I understand it. So I understand your concern and your position, and I'm in essence denying that request, and we'll proceed with all evidence. Then Mr. Tilley, you had another issue.
Well, I just wanted to add, you almost already said it, so I hope this may not be real necessary, but it was turned down. I mean, that's the point. Back in February, Judge Kromkowski did turn down as emergency relief and said, bring those issues up in the hearing. And, so I for her to request you to do this today is I mean, that's not something that's, as I understand it, that's really before you. The issues, I mean, she could ask to have his parenting time suspended, along with other relief that she's, including custody, primary physical custody. But there's the emergency relief that she sought back in February was actually turned down, and the issues were reserved for, today's hearing. But you've kind of said that. I just wanted to.
Yeah, I don't think she's arguing that whether it was denied. She's arguing that it was set for a hearing today, and she wants a decision on that issue today. It's a fair request, but I'm denying it that for the reasons stated. Okay, I thought there was another issue. I assume you don't have an issue with that ruling.
No.
Okay,
I don't think
there
so.
was another issue I thought you wanted to bring up. Sorry, that's what I was referring.
No, sorry, I don't think so.
No other issues that we want to address before we get started?
I think we've covered pretty much everything I can think of.
Okay, then I guess I'll finish just by saying until the court makes a decision on these issues, it's just reminding both parties you have to follow the orders that are already in place. That's all.
Thank you.
So,
Your Honor, obviously there's a practical urgency here, and for my client, and I would welcome the for instance, like speaking with Miss Boyd on or off the record. I mean, about what her problem is, particularly today. Apparently something has come up in the last 12 hours or less. And I'm in the dark about it at the moment. And, I would appreciate an effort to speak to Miss Boyd. Sometimes conversations bring fruit, so I mean, I guess I would ask for that. That has occurred to me. And at some point, not right now necessarily, but, before this afternoon exchange doesn't happen or does happen, I'd like to have a chance to, maybe assuage her concerns somehow or another. That's all.
well, I can try to facilitate a conversation. I'm not particularly, I am not willing to allow the two of them into a breakout room to speak.
No,
there's a PPO in place, and there's a PPO violation hearing on the 13th. So they're going to have to express those types of issues there. I'm not.
I was suggesting myself, and her. I mean, I'm.
If she's willing to speak with you, I'll allow that. Otherwise, you'll have to take care of that issue.
Obviously, she doesn't want to. I agree.
My issue is nothing's been filed for what you're not even putting on the record. What occurred? We spoke off the record that there's an alleged exchange issue. I could only, because that's not right for the hearings scheduled today. There was nothing I can do about it except for just remind the parties you have to follow the orders. If you're taking any other action, Mr. Tilley, you are well aware of how to do that. I don't know if you all want to have a conversation about it. I'm okay with that, but look, I'm not going to force these parties to speak in a breakout room about it. I'll likely be present.
Well,
because it's not about settling these case issues, but if they're not going to figure it out, I'm not going to push the issue, because we're here day one of possibly 3, and we're here for the issues that have been raised and noticed. That's all I can say.
May I say something to my lawyer real quick, please?
Well, that's all. I was going to say that yourself, Your Honor. I haven't.
Yeah. Do you want a breakout? Is that you want to be? You want to be?
Maybe that would help. That might help.
Okay, but let me suggest this too, and I'm fine with this, of course. If we were in a courtroom, you'd just be able to speak at the table. I acknowledge that, but this issue, while I understand it's a concern for, it sounds like for all parties, both parties, it's not noticed for today, so I'm not going to spend a whole hour or something doing that, right? I mean, we can have a conversation, try to figure it out. If you can't figure it out almost immediately, or at least, 15, 20 minutes, we're starting back on what's noticed for today.
I get it.
Because I'll say it this way, because of the way, the case is what it is. Because of the constant ongoing issues, the court cannot decide every issue for you both every single day. I've said that during the show cause hearings, and I have to repeat it today. So when people get discouraged because I can't make a decision on every single issue every single day for these parties, it's because this isn't the only case I have. I have hundreds and hundreds of cases. You have 3 days set aside to spend on your underlying child-related issues, and that's what we're here for. So I'm happy to put you in a breakout room, but I hope that each day we come back, because we have, next week and then the week after, I hope that we're not trying to use those hearing dates to cover ongoing issues. You have to file things, and they have to be noticed for the appropriate issue. That's all I can say. From my perspective, I've covered the issue in terms of saying you got to follow both parties need to follow the order. But if we want to discuss the issue you've raised this morning, I'll give it a few minutes here.
I could just talk to my client.
Yeah. All right. We'll go off the record. And
thank you.
Just give me a second, because it's the. Okay. We are back on the record on case number 2110643DS. I haven't spoken exactly with the parties about what they talked about. I guess I didn't really talk at all, other than I know that we're going to proceed with the hearing. So did we at least resolve the issues you wanted to resolve?
I'm afraid not. If you
Okay.
Not
All
really.
right, then we'll have to pursue. I don't mean the whole case. I mean for the one issue we went in there on.
Even that, unfortunately.
Okay. All right. Well, at least it's stated on the record that that's what occurred. I just wanted to let the I can't inform the record what happened, because I actually don't know, other than I was told we're ready to go back on the record. So, were there any other procedural issues before we start the overall hearing here?
The only other thing I would like to bring up is, and maybe this is after we do opening statements, but just asking the court to take judicial notice of some of the earlier proceedings. I believe the transcripts were filed specifically for the January 10th hearing, the June 12th hearing, the July 14th hearing, and the August, I think it was August 14th hearing, as well as take judicial notice of, the court file as it relates to orders, and the PPO proceeding. I know that the hearings this past summer in June and July were in front of Judge Kromkowski on the PPO, but those were also conflated with some of the custody issues. And I think those transcripts were filed in both matters.
Any comment, Mr. Tilley?
I mean, maybe we should deal with it when it comes up. I'm not sure if just a blanket take notice of all these transcripts is appropriate. I'll leave it to you, I guess. It seems, I mean, I don't know why you couldn't. I guess they're filed, and
I think the only thing that I'm necessarily comfortable with taking judicial notice of would be things that are in the file as records. Because some of the hearings, I didn't go through your list as you were stating them. You probably have a list compiled for trial prep, but I could take judicial notice that someone filed a transcript. I think, but as you mentioned, some of the hearings were not in front of me. And unless there's a transcript, because this came up, I think, in the last show cause hearing we had, I have no idea what goes on in those other hearings that you have. I don't follow. I read the file in this case, but I don't appear at those hearings. I don't have anything to do with them unless there's a transcript filed for a specific purpose. So I don't know. I guess I would I guess
And all the,
to an extent, I would agree with Mr. Tilley that let's bring each thing up individually, and then I can see whether it's something that I can take judicial notice of. So, for example, with the PPO hearing, I know the case number, but I don't know much about that case. I haven't been involved in any of it. And in fact, that was part of my ruling on the last show cause issue is I don't know what. I don't know. Well, I know that I can't affect those proceedings. If you're filing transcripts of what was said in court, that's an official record. I assume so.
well,
I
and
just
that's all
don't know. I can't confirm. Let me say it this way. I can't confirm that without me digging a little, which I have not done. I cannot confirm whether any transcripts have been filed in the PPO case. I haven't read a single page of any of that if they've been filed, and I don't know. I know I've seen transcripts filed in this file, but I can't say for certain whether those are other hearings. Meaning
well,
the PPO hearing. Sorry, I'm trying to type in the case number here.
sorry, maybe I can clarify. So the two transcripts that the PPO hearing included was June and July. Those transcripts were filed both in this matter and the PPO matter. So, and the transcript has both case numbers at the top of the caption. Again, because they were sort of conflated with show cause and other issues. So all I'm doing is I'm not asking the court to necessarily review the PPO file. I'm just saying that there are PPO matters that were included in those transcripts and I believe have been filed in this DS case. I'm simply just asking the court to take judicial notice that those transcripts are a part of the court file. And I'm just asking that the court be able to review and reference those as necessary. I do have them as proposed exhibits as well. I don't know if you want me to officially admit them as exhibits, even though they're part of the court record already.
I think if here's the way I would recommend we handle it. I don't want you to have to print off those transcripts if they're in the file, save you some of that money, right? That's okay with me, because if it's in the file, I can just click on it and read it. I read pages like that all the time. I think it'll help the record if, as you're discussing those issues or whatever the transcript is or whatever, we bring it up then you can have it considered as an exhibit, and I can take judicial notice of it if it is in fact, that part of it. And Mr. Tilley can make comment on that once it arrives, once it arises to that request, I guess. So yeah, I guess I think I have to take judicial notice of everything that's in this file, but
okay, that's all
I'm just saying, I'm glad for the clarification, because what I'm saying is I know that part of my decision on the last show cause hearing I made was I have no idea what's going on in these other hearings, which is true. And I know that the transcripts were filed after, or maybe, I don't know. But when I was doing that RO, I did not have the transcripts. And I that's, so if you're wanting me to consider official court records, we'll consider that as we go. I think that might be a better way to handle it. And that way,
okay.
We have specific rulings on evidentiary issues in case there's an objection, and then Judge Krumkowski can review this as well.
Okay.
So thank you for the clarification. We'll hold off on just taking a total judicial notice, and we'll address it individually. So thank you. And then we're ready, I believe, to start with openings. Is that correct?
Yes.
I mean, Ms. Boyd, are you planning to give an opening statement?
No, at this point, I'm just going to waive an opening.
Oh, okay. Mr. Tilley, are you planning on giving an opening statement at this
Well,
point?
I happily waive it, I guess, until the beginning of our proofs, at least.
That's fine. Okay. All right. So openings waived. Making note of that. All right. So I'll just turn it over to you, Ms. Boyd, your first witness, please.
I will call the defendant, Mr. Kyle Santilli.
you.
All right, Mr. Centilli, if you'd raise your right hand, please. Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Boyd.
Thank you, Your Honor. Can you please state your full name for the record?
Kyle Graham Santilli.
Do you recall testifying previously in this matter?
Yes.
Do you also recall testifying in the personal protection matter involving you and I in June and July of 2023?
Yep.
Isn't it true you previously testified that you committed acts of domestic violence against me?
Yes.
Isn't it true you have stated you want to kill me?
Yes.
Isn't it true you've stated that you wished I was dead?
Yes.
Isn't it true you testified that you used violence to intimidate me during our relationship?
No.
You don't recall testifying that you broke your hand and that you did so to show me how much damage you could do?
I think you're taking that quote out of context, but yes, I said something similar to that.
Did you ever have an opportunity to review and read the court's decision after that PPO hearing, the order denying motion to terminate personal protection order dated July 18th, 2023?
Yes.
You're aware that the court found that you committed acts of domestic violence, correct?
Yes.
You're aware the court found that you committed acts of stalking, correct?
I didn't read all of it, but I read some of it and I never got to that part of it.
I'm going to bring, if it's okay with the court, I'd like to bring up that order for reference.
Yes. You'll share screen.
Yes.
Yeah.
For reference, this is plaintiff's proposed exhibit 11. Mr. Santilli, can you read the case number in the top right corner of the document?
2023-11033 PP.
And under, I believe this is number 2, the box is checked. Can you read what the court finds?
The court finds a motion was filed to terminate the personal protection order dated May 19th, 2023.
And when it says it is ordered, can you read which box is checked?
The motion to modify.
If I could interrupt real quick. So is this a court order, Ms. Boyd?
Yes.
Mr. Tilley, any reason why, any objection to the court taking judicial notice of it being an order?
I can't think of any, I guess.
I just don't, just for the way I usually handle my case, I don't like exhibits read into the record until they're admitted. I will admit this. I'll take judicial notice of it, and there's no objection. So I'll admit it, and now he can read from it. But
Thank you, Your Honor.
Thank you.
It is ordered the motion to modify, extend, or terminate the personal protection order is denied, and the existing personal protection order will expire on the date of that order. This order is effective when signed July 17th, 2023.
And further down, this would be page 2 of that order. At the top, can you read MCL?
MCL 600.29501B, assaulting, attacking, beating, molesting, or wounding a named individual.
And can you read the last sentence here before the bullet point?
After listening to and observing both parties, the court finds petitioner's testimony more credible and that respondent committed act as defined in MCL 600.2950.
And the next bullet point, can you read the MCL?
MCL 600.29501C, threatening to kill or physically injure a named individual.
And you admit that you've done that repeatedly towards me, correct?
Not towards you, but I've said that I wanted to kill you, yes.
And you've also told me that you want to kill me, correct?
Don't believe so.
You don't believe you've ever told me that you want to kill me?
I don't believe so.
Do you recall stating that you testified, or I'm sorry, I'll withdraw the question. Do you recall testifying that you informed me that you hoped that I would die when you put your hands around my neck?
Yeah.
Is that not a statement threatening to kill me?
No. Hoping. I've said that I hope that you die. I guess I'm confused. No, they're not the same to me.
You don't recall stating that I should kill you right now?
What time? No, I don't really recall. No.
Well, the court will take judicial notice of this order and be able to read through the statements that the court has used to make a finding. And I believe that will be one of those, so I won't belabor the point too much more. Can you read this bullet point here at the top?
MCL 600.2950, interfering with petitioner at petitioner's place of employment or education or engaging in conduct that impairs petitioner's employment or educational relationship or environment.
And you admit that you went to my law firm, correct?
Yes.
And you did so with the intent to inform Adam that I was denying you your rights, correct?
No, I went there to get our daughter from you. And then since you weren't there, then I went in and I talked to them and asked if I could file a complaint to Adam about you not giving me my rights as a father.
Have you not stated to other people that it's your intention to have my law license revoked?
Yeah.
In addition to stating that you intend to get sole physical and legal custody of our daughter, correct?
Yep.
And that you only believe you could have a normal life after those things are done, correct?
Yep.
Can you read the bullet point at the top?
MCL 600.2950, engaging in conduct that is prohibited under section 411H or 411I of the Michigan Penal Code 1931 PA 328 MCL 750.411H and 750.411I.
And one of those that it references is harassment, correct?
Yes.
Is it your intention to cause me emotional distress in making harassing and threatening statements?
No.
What is your intention when you make those statements?
Most of those statements I have made to other people, so they weren't to you.
The objection, Your Honor, doesn't answer the question.
I thought it was reasonably responsive.
You might want to rephrase the question if you're looking for a different answer. I thought it was a response, but
So is it your testimony that a victim can only suffer emotional distress if the threat is directed towards the victim?
Isn't that the definition of a threat?
Objection, Your Honor. It's not answering the question.
yeah, you have to I guess if you don't understand the question, you have to let Ms. Boyd know you don't understand. Otherwise, there's no reason really to answer in the form of a question.
Okay, I guess I'm confused.
You admit that you've used extremely vulgar language towards me, correct?
Yes,
And you admit that at times you have stated that I deserve to be treated in that manner, correct?
yes,
And recently you were sanctioned by the court for your vulgar language, correct?
yes,
Do you recall informing me in December of 2022 that you refused to stop using abusive and vulgar language unless the court reduces your parenting time?
yep,
Is that the only way that you will stop using abusive and vulgar language, is if the court reduces your parenting time?
no,
But that is what you did tell me in December of 2022, correct?
yep,
And so far, sanctions and a PPO have not stopped you from continuing to make those statements, correct?
correct,
And you believe that your conduct is reasonable, correct?
I do,
And you'll continue doing so, correct?
correct,
Do you believe your conduct also violates a civil stipulated restraining order?
I don't understand the question.
I can bring that up for your reference if you'd like.
And I would just ask real briefly, if we're gonna have exhibits on the share screen, if you could tell me what they are first, because I gotta type it into the DCR.
Oh, I apologize.
No, that's not your fault. Here's what happens is when you share screens, then I don't have control over whether this is all nothing to anyone. But now where Exhibit 11 won't be at the exact point when it should be on the transcript, and I didn't want to interrupt the proceedings, so that's my fault. But if you don't mind, before you say share screen, I'll just try to remember, and this goes for Mr. Tilley as well, but I'll just try to remember, type it in, then we're good. That's all.
I'm going to object to the question, by the way, Your Honor, because it calls for a legal conclusion on the part of the witness, whether or not it violates the civil restraining order.
So here's the way, my understanding is Mr. Santilli said he didn't understand the question, and Ms. Boyd's going to bring up the exhibit, and she's going to tell me which it is, right?
Yes, so it's plaintiff's proposed Exhibit 8.
That way it's just in the record on the marker. Okay, so I don't know, I'm not sure I have to rule on that objection because he answered the question that he didn't understand, and that's okay. And now we're going to go over the document. We're good, thank you.
Okay.
For Exhibit 8.
Um,
Am I supposed to be able to see it? Because I'm not
Nope,
seeing it.
I'm
Okay.
still
All right.
still getting there. There we go. Can you see it now?
Yes.
Okay. Mr. Santilli, can you identify this document and read the heading at the top?
Stipulated civil restraining order.
Do you recall entering into this agreement?
Not really, no.
Is this not your signature here down at the bottom?
Yeah.
And you're saying you don't recall signing this document?
I was told by my lawyer at the time to sign it and that it benefited me. I really didn't know or understand what it was.
You didn't read through this at all before signing it?
I read it, but I didn't really comprehend much of it.
So can you read paragraph 3B?
Stalking as defined under MCL 750.41H and MCL 750.411I that includes sending mail or other communications to plaintiff except that the defendant may communicate in a civil tone regarding child-related matters.
So going back to your
So if
previous
if-
test.
I'm
Oh,
sorry,
sorry.
and I know we'll get into a routine of doing this, but this is plaintiff's proposed exhibit 8. Mr. Tilley, any objection to having this admitted?
Well, I had another objection. It's in the, you can obviously take notice of it. It's in the court file. I mean, I don't care if you know that it exists, Your Honor. I guess if it needs to be admitted, that's okay.
I just don't want it to be read on the record until it's been admitted. That's kind of, and so I can, but I mean, you didn't really answer my question whether you objected to it, but I'll just take judicial notice and take your response as non-responsive. I don't know.
I guess not. Okay, I don't object to it.
All right, exhibit 8 is admitted.
Thank you. Going back to your testimony just a minute ago regarding your vulgar language and threatening language towards me, does this now refresh your memory as to what this stipulated civil restraining order states?
Not really, no.
You don't understand what you're refrained from doing? You don't understand the conduct?
Nope.
You understand that this language is exactly the same language or similar language, close language to what's currently in the personal protection order?
Yeah, and I don't really understand that either.
You have an attorney, correct?
Yes.
So if you had questions regarding what these documents meant, you have counsel that you could ask those to, correct?
I guess, yeah.
You've just failed to do so?
I was informed by the sheriff of certain things when I had to sign the original PPO, and I guess I've been confused as to everything because you've told me one thing, my lawyers told me another thing, the judge and referee say other things, the sheriff says other things, everybody says something different. I have no idea about any of this stuff. I'm the only person in this entire case that didn't go to law school, and I keep getting thrown this stuff in my face, being told conflicting things by different parties, and I don't know who to follow, and I try to follow what the ref and the judge say the most because they're the ones that are the actual refs and judge, and their voice has more opinion. So, I mean, I guess I'm really just confused as to it all. So
You understand that a court speaks through its orders? So if something's signed by the judge, then the judge is speaking.
well, again,
that.
I guess I'm confused as to that because, you know, in January 10th, the judge said one thing and you did another thing, and then it became a written order, and then you all of a sudden decided to follow it. So and even now at the beginning of this, Hagen's saying follow the court order, yet it's not being followed. So again, I'm confused as to it all because there's just so much conflicting information on this that I don't know who or what to follow, but I try my best to act within a reasonable guideline of myself. And I think when other people see how I respond and react to every situation, that it's well within normal circumstances. Yes, sometimes I overreact, but not once has somebody said your reaction to this is so grossly out of proportion that you deserve to not have your child and be thrown and locked up in jail.
Is that what you're waiting for before you will stop with your vulgar language and your death threats?
I'm waiting for you to treat me like an actual human being and stop accusing me of poisoning our child, getting her sick, accusing me of being a child beater, child molester, my family to be child molesters. I'm waiting for you to stop instigating me.
So you're saying that you have no control over your conduct. Your conduct is simply just a reaction, and it doesn't matter what, it doesn't matter. You just have no control, correct?
No, that's not what I'm saying at all. I'm saying that I have way more control than you do, and that I ignore your bullshit a lot, but a human being can only take so much.
And are you saying that you've reached your tolerance for how much a human being can take?
No.
So you're still within your tolerance of what a human being can take. You just continue to act in ways that the court has restrained you from doing, correct?
Every day is a different day. Every day you wake up with different problems. Some days you're stressed more than others. So some days I can handle your bullshit and other days I can't. So I don't know what you want me to tell you.
And those days that you can't handle my bullshit, you're stating that you don't believe you have to follow any court order, correct?
Well, since you refuse to, I guess why should I be any different?
So your conduct is based upon what I do.
I figure that if I don't follow the court order because you refuse to follow the court order, I can't get in any more trouble than you can. So, yeah, that's my logic.
So you don't believe that you need to follow the personal protection order, correct?
I follow it to the best of my ability.
You've previously testified that when you get angry, you see red and you don't remember what you do or say. Do you recall that?
Sometimes, yes, I get that upset, as does everybody.
Are you trying to normalize your aggressive and abusive behavior?
I'm trying to say that it's a perfect reaction when people mistreat you, that it's okay to get angry and upset.
You believe that everyone has a restraining order against other people due to having normal reactions then?
I don't understand. I guess I don't understand that. I mean, everybody in the world could probably get a protection order against somebody, but if two people get in a fight at a bar, they're not going to get a protection order. They're just going to be told, don't go to the same bar, avoid the people. But not everybody's forced to interact with somebody that they can't get along with because they have a child with them.
And you refuse to modify your conduct in any way, despite, again, there being a stipulated civil restraining order as well as a personal protection order, correct?
I have modified my behavior drastically over the years, unlike you.
But you still refuse and you still continue to use vulgar language and make threats towards me, correct?
I don't make threats towards you. I use vulgar language on occasion, and compared to at the beginning of this, when I used vulgar language daily, as did you, I would say that it's improved drastically over the years.
So again, you're blaming me for your use of vulgar language because that's what I do, correct?
I'm not blaming you. I'm saying that it's a perfect reaction to be vulgar when somebody's disrespecting you.
You're essentially, your testimony today is that you have no control over yourself and that your only actions are reactions, correct?
No, that's not what I'm saying at all. I'm saying every day is different. Some days I can control my reactions, and some days you piss me off to where I can't control my reactions.
And when you can't control your reactions, that's when you send me death threats and use vulgar language and stalk me, correct?
No.
You don't believe that it's normal for a person to have reactions, to be afraid of you when you make and say and do those kinds of things?
I think if somebody is afraid of me, they're not going to storm a psychiatrist's office and demand my child from me if they're afraid of me. I think if
That's
somebody's afraid of me, they're not going to continue to talk to me the way that they do and refuse to follow the court order.
so the way that you treat me is an attempt to modify my behavior, correct?
No,
Your testimony was just now that if you behave in a different manner, you expect me to do something differently. No?
I don't believe that was my testimony at all. I believe what I'm saying is that I react to you. My reactions are not to do anything except express how I'm feeling at that time.
Which is wishing I was dead, correct?
I yeah, I hope you died. Like let's be honest here. We hate each other. If one of us just coincidentally happened to get in a car accident and be taken off the face of the planet and the court never had to deal with our bullshit again, it would benefit everyone greatly. Now, since I'm involved in that equation and I kind of don't hope that I die myself, like obviously I'm going to hope you die, as I'm sure you hope I die, because then it would just, you'd get full custody. Like it would solve all of our problems.
Sorry, I just needed it. You believe our daughter would be better off without one of us?
I do.
Have you ever lost anyone close to you before?
Yeah.
Who?
My father.
Your father died?
He has dementia. He's not the same person. He can't remember anything. So he might as well be dead. He's physically alive, but it's no different than being on life support. I can't talk to him. I can't have father and son conversations with him.
It sounds like that's upsetting you.
Very much so.
Do you think it would be upsetting for our daughter to not have one of us in her life?
I think that up until now, one of us has been removed from her life against their will. I mean, let's be real. We've been court ordered to have 50-50 for the last year. Literally, November 30th is when this court order went into date. Yeah, I have all these dates right here of days that I have missed. November 30th, pretty much all of December of last year, a lot of January, a few days in February, March. I haven't seen my daughter in 2 weeks. You're not even agreeing to file the court order and do an exchange tonight at 4:30. So I think she's already lost me. As far as I'm concerned, I haven't gotten to spend that much time with her.
You lived with Emberly and I for the first 18 months she was alive, correct?
Yeah.
And during that time period, do you recall requiring me to leave her with your mother, otherwise you would break up with me?
No.
You never said that I needed to leave Emberly as an infant with your mom overnight so you could get sleep. Otherwise, you would break up with me.
No, I said we needed breaks.
From our daughter.
Yes.
Do you recall getting upset with me for picking Emberly up from daycare early?
I believe what I remember is that I was upset that we were paying for daycare and that our daughter had a chance to go play with other children, and you continuously kept picking her up from daycare and didn't want her to be around other people. You wanted to smother her with your love and affection.
Do you recall being upset with me that I would, after working my externship with Craig Elhart's office, go and pick Emberly up from my mother's house who was watching her?
I don't recall that, no.
You don't recall wanting me to leave her with her the entire day so that way you could get more sleep?
I don't believe it was worded that way. Like, it was the way that, and this is one of our hugest differences, is you believe that like our child's just supposed to be
Objection,
around her parents.
non-responsive.
It's hard for me to tell. It's an open-ended question, so I don't know. He's kind of answering it.
Well, he's talking about my belief and he can't testify. I mean, that's speculation.
Okay, I won't talk
Okay, then
about your
that's a different objection. I don't know that it's not.
Okay, objection, speculation.
So as to what she says, but you could continue on with your answer unrelated as to what she believes. I'm sorry, I misspoke. So you can continue to answer, just not about what you believe Ms. Boyd believes, if that helps.
Okay. My belief is a child should not be around their parents the whole time. Like, we're not the only ones that want to be around our daughter, and our daughter doesn't want to be around us 100% of the time. It's perfectly normal and healthy for our daughter to be around her grandparents, her aunts, her uncles, her other family, other children.
This was when she was an infant, though, correct?
Yes.
So we're talking about an infant who
Needs to have
doesn't,
who needs to have bonds with her grandparents. Yes.
and you believe she should have bonds with all of her grandparents. Is that your testimony?
At that time, yes, I believe that. As of now, no, I don't believe that.
Do you believe it's important for Emberly to be bonded with her parents?
Yes.
Do you believe that you followed this court's orders and directives in both the personal protection order matter and this matter?
I can you be more specific? Follow the court orders as to like to the T, like do everything?
Yes, do everything that the court has ordered.
No.
Because you continue to make vulgar and derogatory comments towards me, correct?
No, because I have a mind of my own, and I don't believe that our child's life should be dictated on every step of the way by a court.
So if the court orders something, if you believe something different, you won't follow it, correct?
If I have a reasonable and logical explanation or backing from another professional, correct.
Your testimony today is that you believe it's appropriate to treat me in the manner that you have, correct?
Yes.
And that you're going to continue to do so, correct?
Again, since I'm not treating you any specific way and it's all reactionary, Yes. If you continue to push my buttons and instigate me, yes, there may be times where I lose my patience and I explode. Yes.
Isn't that providing me with a reasonable belief that you will hurt me?
No.
So when you explode, I shouldn't be afraid that you're going to hurt me. That's your testimony.
Well, considering I haven't hurt you physically in over 3 years, and I've had plenty of opportunity to, and I've exploded a lot of times over the last 3 years, yeah, I think you're pretty safe.
But you can't guarantee that, correct? Since you see red when you get angry and that you may explode at any moment.
I can't guarantee anything. I don't know what's gonna happen. I mean,
Even though you're in
if
control of your own actions, you can't guarantee that you won't explode and hurt me, correct?
if you show up to my house, I can't guarantee anything. So no, I'm not gonna throw guarantees out, because if you show up somewhere where you're not supposed to, like, I can't guarantee. If you try to steal my daughter from me or something, or you come and threaten me with a weapon, I can't guarantee anything. So I'm not gonna throw any guarantees out.
Do you recall in September of 2023, I informed you that I had found a therapist for Emberly?
Yes.
Isn't it true that you called the therapist and canceled Emberly's appointments with her?
Yes.
Isn't it true your attorney did the same
Yes.
at your directive, correct?
I didn't ask him to, but he did anyway.
You and I can't agree on legal custody issues at this point, correct?
Uh, we can agree on things, just we don't really have real conversations where both sides listens to each other.
In order to obtain services for our daughter for mental health, which you did agree to in July of 2023, I was forced to obtain an ex parte order allowing her to attend therapy, correct?
Correct.
And you did agree at one point to allow our daughter to attend therapy and agreed that she should, correct?
Sorry, was this July 22,
23.
Okay, all right.
Yes.
And then you changed your mind, correct?
After talking to a child therapist about seeking their services and hearing what they had to say to me, yes, I changed their mind, which my response is in your motion.
And you've actually tried to change Emberly's school without my permission, correct?
Correct. Well, I didn't change her school. I signed her up for school in the hopeful case that this would have been solved long before now, and I would have been able to enroll her in school.
Because you want sole legal custody, correct?
Correct.
Have you had an opportunity to read through the custody evaluation completed by Kyle Scott?
I've read some of it, yes.
Have you read his recommendations?
Yep.
I'm sorry?
Yes.
Do you recall one of his recommendations being that our daughter should attend therapy?
Yes.
You still disagree with that?
Yes. If you'd like, pull up your motion and we can read my response right from the text messages, and I will explain why I disagree with it.
Do you recall testifying in January of 2023 that you lied to both me and our pediatrician regarding whether or not you gave our daughter medication?
Yep.
Do you recall informing me that you'll do that again if necessary?
Yep.
And you don't believe that that's a harm to our daughter, correct?
Correct.
So from here on out, both me and the pediatrician are to guess whether or not you're informing us correctly and truthfully of what you gave her.
No, I've had a conversation with the pediatrician since then, and she has always had the stance that if there is vital information to ask of me, she knows to call me rather than trust your word about what I say.
You admit, though, you did lie to her, correct?
Yes. And she didn't have
And
a problem with it.
And that you will testify. Objection. I would ask that that be stricken from the record. That's hearsay. Dr. Galdas is going to testify. I have her subpoenaed at 1, so.
Good.
It's not hearsay. Her not having a problem is not, I would, argue is not hearsay.
Well,
But I welcome her
there hasn't-
testifying.
the problem is that I would only have to guess as to whether that's statements made for medical purposes. We didn't really build a foundation. I don't know if you're planning on building more of a foundation, because if it was for medical treatment, then it's not hearsay, or it's an exception. So
it's not for medical treatment, and that's not where I was going with that. And again, Dr. Galdas is going to testify, so.
Good. I'll enjoy talking to her and having her view on this all.
all right. I think how is it not? I don't know. The only way I mean, it's up to you. I can let Mr. Tilly voir dire on whether or not there's a foundation to support the exception. I don't know, like from your question and the line of questions, it seems like medical treatment. I don't know how Ms. Boyd, you're saying it's not about medical treatment.
Because all he did was call her and explain why he lied. That's not for
Well,
medical treatment.
but now you're testifying about it. That's not the foundation
No,
you
that's
developed on the record.
That's what he testified to.
But based on your questioning, why would I think that he's not talking to a doctor about medical information?
Because he just testified he lied to her. Okay,
But the response is from the doc. He said the response from the doctor was that, I mean, this is a summary or paraphrasing, but that she didn't have a problem with it. That statement to me is her response in a conversation about medical treatment, unless you can help me find otherwise.
I mean, there was no testimony that took place at a doctor's appointment. He said that he had a conversation with her. So
I don't know that the hearsay objection states that you have to have a doctor's appointment to talk about medical information.
So again, I'm fine moving on. If your ruling is that it's overruled,
I'm just suggesting that you haven't disproven that it fits within the exception. I'm giving you that opportunity. That's all.
I would just rather not waste the time and move on. Dr. Galdas will testify.
And that'll be fine too. And you'll be able to follow up. But that's all I was getting at is we're welcome to go down the road. But as far as I could tell, and I haven't seen anything that would be give me one sec. For the course purposes, rule 80 MRE 803 4. But as long you said you're fine moving on, your objections noted, or at least your disagreement. So we're good there. That's my ruling, and we'll move on from there.
Thank you. Mr. Santilli, you previously informed our daughter how much you hate me, correct?
No.
You don't recall texting me and informing me that you told our daughter that you don't like me?
I said that we don't like each other, but I never said hate.
Did you tell our daughter that she would be better off if I was dead?
No,
Has your family told our daughter that I would be better off if I was dead? If she would be better off if I was dead?
no,
No one in your family has informed Emberly that you hate or dislike me?
nope. No one in my family talks about you in a positive or negative way.
Do you allow our daughter to talk about me while in your home?
Absolutely.
And you always have. Is that your testimony?
Yep.
When our daughter was learning to say words such as mama and dada, you didn't let her say mama in your home, did you?
That's not true at all.
You allowed her to say that?
Absolutely.
And you allowed her to say that all the time with no objection, no issue.
As long as she wasn't calling me mama, yes.
Did you ever punish our daughter for not calling you the correct name?
No.
And you believe, just to summarize your prior testimony, you believe it would be in Emberly's best interest if I were dead, correct?
Yes.
Do you believe our daughter picks up on that if you haven't outright told her?
No.
You don't believe that she picks up on your feelings towards me?
I believe that our daughter has picked up on the animosity that when we used to do exchanges, and has an extreme discomfort when we get around each other, whether it be at the doctor's office or during exchanges or at school events. Yes, but I don't believe that's solely based off of me and my feelings. I believe that's based off of how me and you have interacted in front of each other, in front of her.
But you're also assuming that I harbor the same feelings towards you that you have towards me, correct?
Again, it has nothing to do with feelings. I believe that she has picked up on our chaos and animosity based on how we act in front of her.
That wasn't the question. The question was, you're assuming that I harbor the same hate and animosity towards you that you have towards me.
I know that you hate me, but I don't think that
How do you know that?
You've done nothing but try to take my child away from me from day one.
So that means I hate you?
Well, it doesn't mean you love me and think I'm a good father.
But that doesn't mean that I hate you, correct?
Well, considering you've accused me of sexual allegations with my daughter, you've called CPS on me, you've done well child checks that were undeserved, you've called me unsafe to be around my daughter, you've accused me of literally everything bad. I don't understand how somebody can accuse somebody of something like that and not have negative feelings towards them.
But that's your opinion, correct?
I mean, I guess, yeah, but it's pretty obvious to everybody that you have negative feelings towards me.
Has it occurred to you that I'm concerned about our daughter's safety while she's with you, and that's the end of it?
No.
It couldn't possibly be that my concern is about our daughter's safety. Is that your testimony?
I don't believe that you have a valid concern to fear our daughter being with me. No.
Even after you've committed domestic violence and made death threats and continue to do so, correct?
That was all towards you and had nothing to do with our daughter. And
I was holding our daughter during one of those incidences, was I not?
And you hit me while I was holding our daughter, and you yell and scream at me in front of her. What's the difference?
I was holding our daughter during one of those incidences, was I not?
And an hour before you hit me, or
objection, Your Honor. I would ask to strike the testimony. He's being non-responsive.
I literally it's difficult for me to determine that if you interrupt. So I know that the two of you are arguing, but I can't juggle. I try to do this and you're interrupting. So I can't juggle when the two of you are going to speak.
Well, I've asked him 3 times now that I was holding our daughter during one of the domestic violence incidences, and he goes off on a tangent. I'm asking.
I believe
the
he
court
said he did. He was holding her once.
I said I was holding her, and he didn't say that. But I guess that maybe
I believe that.
misheard.
I thought I heard him say that, but maybe he didn't.
Okay.
I thought he said that too. I thought he said, you hit me while I was holding our daughter.
Right, but the question was, I was holding our daughter during one of those incidents.
I understand that's your question. I believe that he answered yes to that, but you can ask him again to confirm. I thought he said yes.
Mr. Santilli, was I not holding our daughter during one of those incidences where you committed domestic violence?
Yes, as have you.
But to be
You're
clear, and this is part of Ms. Boyd's objection, sir. Adding the extra part is what she's objecting to. Okay, so when you answered her question, Mr. Tilley will be able to talk to you about anything else he thinks on we'll call it cross for purposes of this. I'm just telling you, when it gets difficult for me to handle individual objections and statements when we're asking questions, they kind of go on sometimes, but then there's interrupting and it turns into just the two of you arguing. Okay, that's all. It just makes it difficult on the court to make individual findings, and I understand that you're all getting heated here, but that's all I'm saying. I'm admonishing you, sir. Also, when there's a question, you have to answer it. But I guess if there's any more interrupting, I'll deal with it that way too. But there certainly was both in those exchanges that I'm trying to figure out. Okay.
Okay.
All right.
If it's okay with the court, I'd like to bring up plaintiff's proposed exhibit 22.
Yeah, just give me 1 second, please. Okay, there we go. You're welcome to. Thank you.
So it is an audio file, or I'm sorry, this is a video.
Have you all gone over the videos and
This video was redacted for hearsay from the minor child.
okay.
I don't know if I've seen this, if that's what you're asking, Your Honor. I may well not have.
It was included in my proposed exhibits in the flash drive that I dropped off 2 days ago to your office.
Right, which I have not had a chance to look at.
I don't know what to tell you.
Well, when did you receive it, Mr. Tully?
I
I received a package of things on Monday, at least.
think it was, no, I didn't receive this Monday.
I haven't reviewed them. I'm just telling you, I got an
Yeah.
email saying, "Hey, plaintiff dropped stuff off. Come get it," and I did. It's sitting next to me, but I'm just
December 5th, 2 days ago, I have an email from Ms. Boyd saying, just a copy of, I guess, the one, it would have been 2 days ago, December 5th, I think it was 2 days ago, and I haven't had a chance to look at it. I mean, I've done a lot of prep. I've spent a lot of hours on this case, and I was sifting through my own documents, of which there are hundreds, of course. I'm just saying I haven't gotten to it. It may be something I'm familiar with, actually. I don't know what it is.
You are. It's I guarantee you it's one of the videos that I sent her of me interrogating our daughter.
Okay, I may be familiar with it.
I'm fine with it.
I mean, also, Your Honor,
I can do it 2 ways. One, we're breaking for lunch in 4 minutes. So, because it sounds like Ms. Boyd already has a witness set up at 1. So we're going to break for sure at noon. You can have that opportunity to watch them, but your client's already suggested that we can watch it.
He provided these.
Exactly. I think I'm familiar with it. It sounds like I'm familiar with it. So if she wants to play it, I guess that's okay.
Okay, that sounds to me like a way of saying there's no objection, so we can go into exhibit 22. Ms. Boyd. I should say it's admitted.
Thank you. Mr. Santilli, this video, does this look familiar to you?
Ms. Boyd, 1 second. I think that we're on the screen where we can't
Oh, is
see
this
the video.
still-
We're on the part where you're clicking on the video.
Sorry.
That happens. I do that. That happens. It's because it
Is
doesn't.
it up now?
Yes. All right.
Okay. Does this look familiar to you?
Yep.
Before we
You
play,
would
it, could you get a little bit into like when this was or anything? For my
Do you
notes?
recall when this video, well, I guess,
Give me a second. I'll tell you the exact date of because it's still on my phone under when it was taken.
It's just helpful for the court to know when things take place. That's all. It's already been admitted, so I'm not suggesting there's no foundation. I just
The
Okay.
video was taken at July 5th at 6:11 p.m.
Of what year?
or July 15th of 2022, which I believe is a Friday.
okay. Thank you, Ms. Boyd. You're welcome to proceed.
okay.
And Mr. Sotelo. Thank you both.
Since there's no foundation issues, I am going to play this video for the court.
I think there's no volume on my end. No sound.
I can't hear anything either.
Okay.
I can't either. Is it playing volume on your end, Ms. Boyd?
It is playing volume. It was. Hang on, let me start at the beginning and
Probably have to change the audio settings.
sorry, I'm just looking to see.
You're fine.
If we're breaking in 4 minutes, Your Honor, or 2 or whatever it is, maybe she can work out the kinks on this volume.
I mean, if the court has, if this has been admitted and the court wants to, the court obviously can review the audio, can review this video. I'm asking to have Exhibit 23, the audio also admitted, that was provided by Mr. Santilli. Similar situation. The minor child statements have been redacted, so that way there's no hearsay issues. If the court and Mr. Tilley want to ensure that those are accurate, and I'm making the representations that I am about those, maybe that's the way to do this. I don't know why the audio isn't working.
So here's what I'll suggest, because I was going to suggest the same thing, but I didn't want to eliminate your ability to ask him questions about it. Okay. Because if we just admit it, I will review it, but I want you to have an opportunity to question your witness based on what we have. So let's do this. What we're going to break here. Are we back? We're back at 1 with the doctor, you said?
Yes.
Yeah, that's perfectly fine. So whenever what I'll do is there, give me a second on this. Mr. Tilley, is there an objection to having Exhibit 23 admitted?
I don't think I have a valid objection to it.
All right, so Exhibit 23 is admitted. So both of them are now admitted. And then this will give you an opportunity during this break, Ms. Boyd, to see if there's anything you can do with the volume. I'll give you another opportunity to try to present it. I'm perfectly comfortable, like I said, reviewing it on my own if it's a part of the zip drive you provided. I just want to make it clear that I'm not going to just say, it's saying you can't ask any more questions about it. That's why, because we have Mr. Santilli on the stand. Once I review it, I'm not going to be asking him any questions, obviously. All the evidence will be presented. So I'll kind of reserve, both of those exhibits are admitted, but we'll reserve reviewing them if you want to try to figure out the audio or whatever on your own. Otherwise, I'll see you all back here at 1. And it sounds like we're going to start with the doctor. And I've already told the parties off the record. It's pretty common, so I can state it on the record too. But we can take witnesses out of order because we have the parties who will be here throughout our entire proceedings, but we are fitting in witnesses when we can. So I suspect it'll happen on both ends, but I'm comfortable starting up with a different witness when we come back, is all I'm telling everybody. All right, we're back on the record on case number 2110643DS. I believe we're going to take a witness out of order at this point. Is that correct?
Yes.
So then I'll just formally ask you, Ms. Boyd, your next witness, please.
Dr. Stephanie Galdes.
Dr. Galdes?
Yes, hi.
Good afternoon. Hi, my name is Matt Hagan. I'm the referee in this matter. You've been called as a witness by
Yep.
Ms. Boyd, and she'll have some questions for you. And then if he chooses to, Mr. Tilley may have some questions for you, okay?
Okay.
Thank you. If you'd raise your right hand, please. Do you swear from the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Ms. Boyd.
Thank you. Dr. Galdes, thank you for appearing this afternoon. If you could please state your full name for the record.
Dr. Stephanie Galdes.
And before we go too much further, just for the sake of continuity, if it's okay with the court, I'd like to share plaintiff's proposed exhibit 25, Emberly Santilli's medical records. And maybe we do want to go off YouTube for this.
I think that's probably appropriate. Any objection to that, Mr. Tilley?
Not going off YouTube, certainly, no.
Right, yeah, we're still on the record. Did you say 25?
Yes.
Okay, great. I've got that in. And then for my purposes, I think it's appropriate to take this evidence off of YouTube based on MCR 8.116D1A to protect the minor's privacy.
Who says that Dada's bad? Mama? And why does Mama think that Dada's bad? 'Cause why? Is that why you think that Dad doesn't love you? Emberly? Is that why you think Dad doesn't love you? Does Mama say that Dad doesn't love you? Mm-hmm. You know that's not true, right, sweetie?
Okay, and since those have already been admitted, I guess jumping back in here. Mr. Santilli, those are audio and video recordings you took of our daughter, correct?
Yes.
How often do you make those recordings?
Not very often.
How many have you made this year?
None.
Those were all from previous years?
I believe so. I think they were from 2022, weren't they?
That's not my question to answer.
I don't know. I'd have to look it up, but as far as I can remember, those were the only 2 times that I've ever had to have those types of conversations with their daughter and that I felt the need to record them.
Do you recall stating to, well, do you recall that there was a hearing in front of Judge Kremkowski regarding you providing supplemental answers to interrogatories earlier this year?
Yes.
Do you recall Judge Kremkowski informing you that while you did need to turn over audio and video, that family members or people who you lived with did not?
I don't recall that part specifically, no.
Do you recall at the last hearing with Judge Kremkowski regarding your answers to interrogatories, you informed the court that you had other people recording our daughter instead of yourself, because then you would have to turn those over to me?
Yes.
Who else have you had record Emberly with those types of conversations?
I never specifically said that we recorded those types of conversations. I've had my mom, my sister, and my aunt all record family gatherings, such as when we go over to my sister's house and she's blowing bubbles, we record using her phone. Her birthday in August, we use my mom's phone, I believe. So yeah, they're just
And that was specifically so that way you did not have to turn over those recordings to me, correct?
Not specifically, but I specifically didn't use my phone. I didn't ask them to take videos or anything, but I didn't tell them that they couldn't.
You understand the nature of the questions that you're asking our daughter or leading?
I have no idea what the hell that means, so no.
You don't know what a leading question is?
No.
You don't find it at all concerning that you're providing our daughter the answer to the question you're asking her within the question?
There's only two answers that it could have been, so no, I don't see the problem.
Do you intend on continuing to interrogate our daughter about what takes place at my home or what I say to her?
Well, considering I wouldn't say that either of those were interrogation, I would say that I've never interrogated our daughter, nor will I ever interrogate her.
Objection, motion to strike, non-responsive.
Well, I mean, to an extent, his answer is no. He doesn't believe it's interrogation. So I don't know. You categorize it as that, and he says it's not. So do you want to?
Okay, I mean, I'll rephrase the question.
Yeah, that's what I'm saying. I mean, I think it's a response because of how it's categorized. But as you've categorized it, if you want to rephrase, you're welcome to rephrase. I believe it was responsive to the question, and you're welcome to rephrase if you'd like.
Do you plan on continuing to question our daughter in the same manner that you have previously in those audio and video files?
Depends on what she says to me. The stuff that she said before I started those recordings were concerning, and if she says concerning things to me again, I will absolutely ask her about them.
In that manner, you will continue to do that.
I don't know what you mean by that manner, but yes, if my daughter says things that are concerning to me, I believe I have as a right as a father to question her about those.
Okay. Do you recall speaking to an Officer Wigton on March 31st regarding this? Sorry, I wasn't sure if you were saying something.
I've spoken to him several times. I don't recall what March 31st was specifically.
Okay, I can bring up the incident report.
This is 2023, is that correct?
Yes.
Okay.
I'm going to go ahead and share screen. Can you see my screen okay?
Yep.
Okay, oops. This is can you read the top of the document, what we're looking at?
Leelanau County Sheriff's Office Deputy Report for Incident 2301583.
And just to refresh your memory, can you read this
No,
summary?
I don't want it read until this has been admitted. Oh, are you asking him to read it to himself or read it out loud? Sorry.
I guess I'm just asking. He said that he didn't recall what date he spoke with him on. So if he can just, I guess, use this to refresh his memory as to the date that he spoke with Deputy Wigton.
He can read it to himself. Maybe that was more of an instruction for Mr. Santilli. Sir, you can read it. Just don't read it out loud yet until it's admitted.
Okay.
Thanks.
Do you recall speaking with Deputy Wigton on April 2nd regarding the threatening statements you made to me?
Can I have a second to read so I could figure out what the conversation was about?
Sure.
Okay. Yes, I believe I recall this conversation.
Do you recall informing Deputy Wigton that you had never committed any physical violence against me?
Yes.
Isn't it true that you did actually commit physical violence against me?
Yes.
You know, objection as to relevance. I mean, she can explore physical violence all she wants, but why is she getting into his honesty or dishonesty, I guess, it seems that's what all she's asking with this police officer. I mean,
It goes to credibility.
Well, part of the issue I guess I'm having is you asked him about dates, you wanted him to read this. You never asked him whether he told the truth to the police officer. You're not technically impeaching him yet on this information. You haven't given him, in other words, you could ask him, what did he tell the officer? You haven't done that yet. And so for you to go into this.
Well, I did. I said, do you recall telling the officer that you didn't commit physical violence? Okay.
Right, but he agreed that he did. So you're impeached.
No, he agreed he did not.
He said that he didn't tell the officer about the physical violence, but then he admitted he has done that. That's what I heard.
Right.
So why would he need to read this to say that?
He does. I can stop sharing. It was
That's all I'm saying. It's a sort of a technicality, but what I'm saying is, okay, so this is what I'm talking about. If you would have asked him in a different way, well, I don't want to convolute the testimony. I don't think that his testimony was contrary to what you were trying to show in that document. In other words, if he would have given one answer and then you show him that and say, well, does this refresh your memory? I think what happened, from what I understand, is he's saying that he told the officer one thing and then you asked him, was that truthful? And he admitted that he has engaged in domestic violence. Does that make sense?
It does. And the only reason I brought up the document when I did is to refresh his memory as to the date. I apologize. I didn't stop sharing.
That's all I'm saying is I don't think he needed to read the document to have that refreshed. The date was all, from my understanding, any inconsistency.
Well, he then asked if he could just look at what he said. I guess I should have stopped sharing my
screen. No one
screens.
did anything. I'm not suggesting people did something necessarily wrong. It's just I think we're all at the same spot. We don't need to go through that whole document that hasn't been admitted.
I wasn't going to. That I was simply, this just goes to credibility. That was going to be the only thing
I'm comfortable with that. So
okay.
the objection's overruled as far as what you are asking. I just didn't want to go through the whole document as it appeared it was that's what was happening. But anyway,
I apologize.
I think that issue's resolved. It's one of those, again, and I'm just stating this for the record, it's one of those where if we were in a courtroom, he'd be holding it in his hand and we wouldn't have the whole thing displayed to me. And, because I'm not reading it. That's what I want everyone to know. Okay. Go ahead.
Okay. So just to clarify, Mr. Santilli, you admit you lied to the police officer about domestic violence, correct?
Your Honor, I do have the standing objection, and forgive me if you've already ruled on this. I'm not sure you have, but I think his honesty or dishonesty with the police officer is really not relevant. I mean, I think he was honest, by the way, but isn't this sort of not germane to what we're doing today? I don't know. So I suggest it isn't. So that's my objection.
I think that whether he's telling the truth is something the court has to determine. That's how trial courts work. So I overrule that objection. I understand you have a standing objection, but you can certainly, I guess the term is at least attempt to rehabilitate that on again, what we're going to call cross, because you'll be able to call your client later for direct, of course, on your case. But anyway, I think that not only is his credibility relevant, but it also is domestic violence is specifically one of the best interest factors. So whether we're being credible as to what I will be directly reviewing under those 12 factors, that's one of them. So I think it's doubly relevant. Now, before we go on with Mr. Santilli, there is a Ms. Woodworth who just popped in. Woodworth popped in the waiting room. So I don't know if you want to start with that person now.
Yes, if I can just real quickly sort of I want to make sure that his answer is on the record as.
I'm just letting you know. You tell me when you want that person in. I was,
Okay.
that person can stay till 3. You said you're calling her at 3. That's the way it can be. But I'm letting you know who's here and all that. So it doesn't make any difference to me, in other words.
Okay, thank you.
All right.
So, Mr. Santilli, if you can answer the question, just to be clear, you admit you lied to the police officer about committing domestic violence against me, correct?
Yes.
Thank you. If we can go ahead and call Christina.
Okay. Let me get this typed in. Ms. Woodworth,
Hello,
good afternoon.
good afternoon.
My name is Matt Hagan. I'm the referee in this matter. You've been called as a witness by Ms. Boyd. She'll have some questions for you, and then if he chooses to, Mr. Tilley may have some questions for you. Okay.
All right, sounds good.
Thank you. If you raise your right hand, please. Do you swear from the testimony you're about to give the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Ms. Boyd.
Thank you, Your Honor. Ms. Woodworth, can you please state your full name for the record?
My name is Christina Woodworth.
Are you currently employed?
I am.
Where are you currently employed?
I am employed with Northern Lakes Community Mental Health.
And what is your current position?
My position is a home-based therapist.
And how long have you been a therapist?
Since November of 2021.
Can you please describe your job and daily duties as a therapist with community mental health?
So as a home-based therapist, we receive the most intensive cases for children with generally high or unsafe behaviors. And with that comes the infant mental health side of services, where we work on supporting attachment and relationships between children and their caregivers. So a lot of what I'm doing is working with parents to help them better kind of manage their kiddos and make sure that that discipline and teaching is age appropriate, I guess.
Okay. And do you hold any academic degrees?
I do.
What are those?
I have a bachelor's and a master's degree in social work.
And do you hold any special licenses?
I'm licensed through the state of Michigan as a limited license master's social worker.
And for how long?
I've had that licensure since October of 2021.
Do you have any special certifications or endorsements?
I am working towards an infant mental health endorsement, but I don't currently have those letters behind my name.
And that would be through the state of Michigan, correct?
Yes.
Are you familiar with, well, I guess at this point, I would move to admit Ms. Woodworth as an expert, not in infant mental health, but as a therapist treating infants for home-based therapy.
I would object, Your Honor. I'm sure, I'm sure she's, an excellent therapist, but I don't know when, last time I checked, a therapist can't give opinions or diagnoses essentially in court. I mean, she can obviously testify about many things, I suppose, but the expertise, I don't know what she would necessarily be an expert on to the court.
Let me just ask a kind of a straightforward question. Is it gonna be necessary for her to be certified? I mean, if she's gonna testify to, I actually don't know this, so is she does she treat the minor in this case?
She has in the past, so
Okay.
it's not necessary. I just figured I ran through the foundation.
I understand, and I appreciate that. That's why I appreciate the candor, because just in terms of
Yeah, I don't want to argue
whether
about
it's
it.
going to be necessary, if that's not a part of what she's here for, then I'm not going to decide that. But I don't think that
Okay.
I don't think that it's an unfair request. But with the objection and the possibility that Ms. Woodworth is here merely for as a fact witness, I think we're going to, let's see if we get the information we're hoping for, and then we'll address the issue. So I guess in a way I'm reserving it, and you can request again, but I'm not at this point sure that it'll be necessary. Okay.
Okay, thank you. Christina, are you familiar with Emberly Santilli?
Yes, I am.
Are you familiar with her parents, Kyle and myself?
I am.
How do you know Emberly?
I was Emberly's infant mental health therapist for just under a year, in the year of 2022.
Do you recall, you said just under a year you were her therapist? So I'm going to, if it's with the court's permission, I'm going to share my screen and bring up her infant mental health records. This is plaintiff's proposed exhibit 46.
And are these sensitive records that should not be on YouTube?
Probably, yes.
Any objection, Mr. Tilley?
Not so far.
Well, okay, to me closing YouTube.
Oh, no, I'm sorry. Yeah, no.
All right. So based on MCR 8.116 D1A, I'm just going to turn off YouTube. All right, we're back on the record on case number 2110643DS. We're going to continue with Mr. Santilli's direct testimony. And just as a reminder, sir, you're still under oath.
Yeah.
Ms. Boyd.
Thank you, Your Honor. Going back, I'm going to, sorry, I'm looking for, Mr. Santilli, do you recall completing some answers to interrogatories in April of 2023?
I believe so, yeah.
Do you recall one of those questions being, or one of those requests to be, provide me with copies of any and all text messages, Facebook messages, and or any other written communication with any third party wherein you've stated wanting to physically harm plaintiff in any manner whatsoever?
Yeah,
Do you recall what your answer was to that?
I believe I said that there weren't any.
That's false though, correct?
You'd have to read the specific question because I believe you asked the question in a different way, and so.
Would you like to see the interrogatories?
Sure.
For the court's reference, I'm sharing plaintiff's proposed exhibit 14.
Thank you.
And the question, I have it in front of me. What number is that?
Number 8.
Thank you.
Can you see that, Mr. Santilli?
Yep.
And your answer?
I don't believe I've made any such statements.
But again, that's actually false, correct?
Not the way the question is worded.
You have, your testimony is that you have not made statements of wanting to physically harm me?
No.
Do you not consider wanting to kill someone physical harm?
I believe that what I've said is I would like to be able to, but not that I want to.
So you're differentiating between those two as a way to avoid having to provide the documents requested?
And the fact that I know that you were stalking me and already had any and all such conversations and text messages, yes.
Objection, strike as non-responsive and argumentative. He continues to bring me up in all of these answers and doesn't, the part that's relevant is the yes or no.
I agree in this case, he did that.
Okay, what happens now? I don't know what that means.
Well, she'll ask you another question.
Okay.
You heard Dr. Galdes testify previously or just earlier, correct?
Yes.
And do you recall those conversations in which she has attempted to inform us of being on the same page and the importance of that?
Yes.
Isn't it true that just last month you refused to share with me the information regarding how much allergy medication you gave our daughter and when?
No.
I'm going to bring up plaintiff's proposed exhibit 40.
And I do appreciate that. We didn't address whether 14 was admitted. I don't know if you were even offering it for that, to be honest.
No.
Okay, that sounds good.
Can you read the very top of this?
App closed. Complete record of text communication. Period. 6/1/2023. 12 a.m. to 11:30. 2023. 11:59 p.m.
And I would move to admit these text conversations through app close.
Well, first, it seems premature. We don't need them admitted. She can read from them and talk about them without necessarily, in my view anyway, that procedurally she can
Referee
talk about
Hagan,
them without admitting them or getting them into evidence.
Yeah, I'm not sure it's appropriate to have evidence read onto a record until it's admitted. That's weird.
Well, I guess maybe we have different views. I thought you could confront witnesses with something that's not necessarily even admissible. That's sort of how
that's what I was getting into earlier today. I agree with that, but that's for impeachment. If someone's admitting to what you're only really doing that to show that someone isn't telling the truth, or look, the word is impeach. So for whatever reason you impeach someone, so that's my understanding of the way the rules of evidence work, is that there's no real they need to be admitted.
well,
I'm not suggesting but that's just part of this. I'm not sure your objection is to whether that's the law. That's my understanding of the law. So whether or not you want this exhibit, if you have an objection for a different reason.
well, I don't think a foundation. I mean, she just said he asked her. You know, she asked him to read something, and then she did, and then now it's admissible. I don't know if that's a foundation. I to have them admitted. I mean, if
Okay,
frankly, if these are accurate, I don't care if they're
Ms.
admitted.
Boyd, you'll need to go through a foundation. And I don't even know from Mr. Tilley's response as to whether he's wanting you to build a foundation for every message, but I guess we'll just go through and try to build a foundation and see if there's any further objections. But right now there's an objection that there's no foundation. So I'm going to allow Ms. Boyd to explore a foundation for this.
Okay, well, I guess in scrolling through these messages, do the dates appear to be those stated as to the period? Do these look familiar?
Yeah.
Have you and I used app close during this time period for communication?
Sometimes.
So your answer is that yes, we have used app close for communication.
Yes.
I think these are admissible, Your Honor. If they're verifiable through app close, they probably are admissible. Because they're, there's a source that we can all go to. I'll just say that, and maybe we can speed this up a little bit, to verify that they're correct, and we can, there's a central source of information for this. So I'll drop the admissibility part just to get on with this, if nothing else.
Well, okay, exhibit 40 is admitted. 4-0, right, Ms. Boyd?
Yes.
Admitted.
And I'm just scrolling through here. Your testimony was that you've never refused, or that you didn't last month refuse to tell me how much medication you gave Emberly and when, correct?
Correct.
So I'm just scrolling to find the date. What kind of allergy medication do you give Emberly, if any?
It's in here. I don't know. You want me to go look real quick?
Actually, here, I apologize, October 30th. Or, no, sorry. On October 29th, can you read your message at 8:45 a.m.?
The pink sweatshirt with Minnie Mouse is mine. And I gave her 2 other pink shirts, and I don't know if that's the pink sweatshirt you're talking about or not, but only pink stuff I had. Gave her children's Claritin last night, and she wasn't hurt.
And then I ask you if you can clarify why you're giving her Claritin and not Zyrtec, correct?
Yep.
And I ask you if you can please tell me what time and how much Claritin, correct?
Yep.
And can you read your response at 8:48 a.m.?
I gave her the correct amount before bedtime. The ruffled shirt is not a sweatshirt, but she is wearing it because Claritin seems to work better for her.
And I then ask you what the correct amount is. And can you read your response at 8:49 a.m.?
I don't know. Why don't you read the bottle and figure it out?
Do you see anywhere here where you tell me how much Claritin you give her?
I gave her the correct amount.
And when I ask you how much that is, do you provide that?
No, specifically, no. But it's
Do you
the
tell me
correct
what time you gave it?
last night or the night before October 30th.
And you heard Dr. Galdez's testimony regarding the importance of ensuring that communication about how much and what kind and when last doses of medication were given is important, correct?
Yep.
You appear not to find that it's important to share that information, though, correct?
I believe I shared that information with you.
You believe by telling me that you gave her the correct amount, that's sharing how much medication you gave her?
Yes.
In reality, you refuse to share any relevant information about our daughter during your parenting time, correct?
Not correct.
Isn't it true that in the past you've refused to share the court-ordered information required?
Before it was changed, yes.
Your statement or your testimony today is that since it's changed, you're following the court order by refusing to tell me when and how much medication you gave.
No, I'm stating that we came to an agreement on November 30th of 2022, and there was a whole bunch of things that we were supposed to exchange back and forth, and we had a hearing about this in front of Kromkowski where she determined that I wasn't in contempt for not sharing this information with you, and then she shortened the list down to essential things to be shared. And since then, I have shared those essential things with you.
How am I supposed to know, based upon the information you provided, whether or not the amount you gave her was a 12-hour dose or a 24-hour dose of Claritin?
You could have asked me that rather than ask the dosage, because you don't know the difference between 5 milligrams and 30 milligrams.
So you could have also just provided me with the information that you gave her 5 milligrams, correct?
You still wanted to know if that was per 12 hours or 24 hours.
You still refuse to provide me with how much medication and how many milligrams or milliliters you provided our daughter, correct?
Yes.
Are you still going to refuse to continue to provide that information in the future?
I mean, I will continue to tell you what type of medication I give you, and if it's the exact dosage for a child our age and weight, or if it's a different dosage.
Did I not tell you in that message that I don't give her Claritin? How would I know what the appropriate dosage is to give her?
Then I guess it really doesn't, like, if you're not going to give her Claritin, then it doesn't matter, I guess. I don't know.
Did Dr. Galdes not just state that it could cause issues if you give different kinds of medication and you don't know how much and you don't know what times? Do you recall
Yep.
her testimony?
Yep.
So essentially what you're saying is you don't care, correct?
That's not true at all.
You care enough not to share that information with me?
I think if we would have asked her specifics instead of generalizations, she would have given a more specific response.
That doesn't answer the question.
And what was the
Are you
question?
just making excuses for your refusal to follow the court order?
I tell you stuff. I don't know, like, you don't
Well, your
need to.
prior testimony earlier today was that you only tell me the things you think are necessary and important, and that sometimes differs from the court order, correct?
Sure. I don't think you need to know exact specifics of exact seconds of exact milligrams or milliliters or exact anything. If we use different brands of allergy medicine, as long as it works, I don't think there will be a problem. Our
Do you
daughter
understand that Claritin is not a different
He
brand,
was
but
in
a different-
mid-sentence. Could he finish the sentence, please?
Sorry, there must be a delay. It sounded like he was done.
I think I was done.
Okay, Kyle, okay,
Sorry.
that's all right.
Do you understand that Claritin is not a different brand, but a completely different medication?
It's not. It's all, like, the main ingredient is what makes it a medication.
You understand that Zyrtec and Claritin are two different medications, correct?
Read the direction or the ingredients, and you'll see that they're not different.
Your testimony is that Zyrtec and Claritin are the same allergy medication?
I believe so, yes.
And if it wasn't the same allergy medication, would that be concerning?
I don't believe so, no.
So you don't believe it's important for me to know, again, when, where, how much of a medication that you're giving
On stuff
during
like
your parenting time?
on stuff like allergy medicine and stuff, no.
Even though we're court ordered to exchange that.
I gave you the knowledge. I gave you the information the best to my knowledge.
You didn't know how many milliliters or milligrams of medication you gave her?
I gave her the appropriate amount for her age.
So your knowledge, though, is actually the milliliters of the medication, correct?
I don't remember how many milliliters. I read the box, I fill it to the line, and then I forget. I don't
Wouldn't
care.
it have been just as easy to provide that information to me?
Is it seriously that much that you need to ask, like, interrogate me for 30 minutes about it? Do you even know what kind of complications could happen from allergy medicine? Do you know what overdosing does and all that stuff? Maybe these are some of the questions we should have been asking the doctor instead of just generalized questions.
So you could have easily provided me the milliliters of how much medication you gave our daughter, correct?
It wasn't that easy. I would have had to go look it up. Yes. But I
And you
guess
just refused to do that, though.
yes.
So our daughter's health is that important to you that you couldn't be bothered to look up the milliliters of the medication you gave her?
Our daughter's health is very important to me, which is why it's been very concerning to me that even when I do tell you the type of medication and stuff I give her, you refuse to give her any type of allergy medicine and do anything about her cough or cold and just take her into the doctors multiple times.
Did I not inform you that I was giving her Zyrtec during my parenting time for her allergies?
You have informed me that you have given her multiple medicines.
Did I not inform you that I gave her Zyrtec during my parenting time?
One time, yes.
Is that not an allergy medication?
Yes.
Is that not an allergy medication that's recommended by her pediatrician?
Yes.
So your testimony is actually false. I have provided her with medication for her allergies during my parenting time.
My testimony is that you have not done so every time.
Objection to the, argumentative question and testifying, the attorney testifying.
I'm not testifying, I'm clarifying his testimony.
I don't know.
I'm done with that line of questioning anyway, so.
Well, I do. So sure, and I can appreciate that, but I do want to say, I mean, we are getting into just you arguing with him. So, and him arguing.
He's also asking me
I just said
questions.
that. I just said that he's also just arguing, but this is a court hearing. It's not an opportunity for two co-parents who don't get along to argue, and I want to make that clear because that's how it's just developing into that. So,
and when I've objected and asked for a motion to strike to his non-responsive, I don't, how would you like me to handle that moving forward? Because I
want you to move on to your next question and take the admonishment seriously. That's what I want.
Right.
I have stricken his testimony and not written it down based on objections. I believe I'm being fair in here. I'm just trying to remind both parties we don't need to argue.
No, I appreciate it, Your Honor. I apologize. I'm looking at exhibits. I can go ahead and share proposed exhibit 33.
Thank you.
33.
Mr. Santilli, does this text message that you see on your screen, or I'm sorry, Facebook message that you see on your screen look familiar?
Absolutely.
Did you send these messages to me through Facebook Messenger?
I did.
I would move to admit Exhibit 33.
Just
Mr.
one
Tilly?
page? Sure.
Yes, it's
Okay,
just
no,
one.
I guess no objection.
33 is admitted. Thank you.
Mr. Santilli, can you read your first message to me at the top?
So duck off, you stupid cunt.
And can you read your messages here in the middle of my screen?
STFU, you dumb cunt. Repeated over and over 4 times.
And what does STFU mean?
Shut the fuck up.
That's normal communication for you towards me, correct?
Not correct.
No, this isn't something you regularly do. That's your testimony.
Correct. That's my testimony.
Okay.
Can I just ask real quick, do you have a date and time for those messages? Ms. Either Mr. Boyd or Mr. Santilli, do you remember when you sent those messages?
That would have been sometime in 2021.
I believe I have August 1st, 2021.
Okay. Any reason to dispute that date and time, Mr. Santilli?
Nope.
Okay, thank you both.
And I'm going to go ahead and share screen exhibit, plaintiff's exhibit 44, proposed exhibit 44.
One second, please. Thank you.
Mr. Santilli, does this journal look, Our Family Wizard journal look familiar?
Yeah.
At one point, did you and I use Our Family Wizard for communication?
Yes.
Do you recall agreeing to do these journal entries at one point for our daughter?
No.
Did you do this journal entry?
I'm trying to see. I guess it says it does. Yep.
Right here, created by you, correct?
Yep.
And can you read the date?
7/9/2021.
And can you read these last 2 sentences of your journal entry?
I'm sorry to do this. I don't want to be pedantic, but could we would you like
Oh,
to have
I'm
this
sorry.
exhibit? I know
I
it's
would
not,
move-
I know that it's not intentional.
Yeah, I would-
Would you like to have this exhibit admitted?
Yes, please.
Mr. Tilly,
I don't think I have an objection, Judge.
thank you. Exhibit 44 is admitted. Thank you.
Can you please read the last 2 sentences?
Do not ever ask how she did. I will write my journal entry when I have time. If you ask, I will delay writing the journal entry because you're impatient and need to learn patience and boundaries.
And you believe that it's your job to teach me lessons in patience, correct?
No.
That journal entry would state otherwise,
Well, it's
correct?
not. You can say what you want, but I don't think it's my place to teach you lessons.
Is that not what that journal entry stated?
Don't think it said anything about lessons, but
Okay. Sorry, Your Honor, I'm just looking for my next exhibit. Have you ever posted on Facebook regarding me?
yep.
And And I'm gonna share plaintiff's proposed exhibit 51,
You,
or actually, I'm sorry, 52.
okay, just give me 1 second to change. All right, thanks.
Does this look familiar?
Yep.
Is this a post that you made on social media?
Yep.
And what is the date of it?
June 15th, 2021.
I would move to admit plaintiff's proposed exhibit 52.
Mr. Tilly,
I guess I have no objections, Your Honor.
52 is admitted.
Did you inform a mutual friend, or did you state at one point that you posted this to trigger me into responding to you on Facebook?
I don't believe I did. No.
You don't recall ever making that statement that you posted this specifically to trigger me into responding?
Nope.
Okay. I'm going to share screen plaintiff's proposed exhibit 53. Does this Facebook post look familiar?
Yep.
And what is the date of this?
June 18th, 2021.
Did you write this?
Yep.
I would move to admit plaintiff's exhibit 53.
Mr. Tilly,
That went kind of quickly. I don't have 50. Can I just take a look? I don't have it in front of me. That's all.
yes.
I mean, I'm sharing it on my screen.
Okay, but I'm pulling it up. All right, thank you.
So your response then?
I'm sorry, did she offer it into evidence or?
Yes.
Yes.
Oh, okay, and he, of course, okay, no objection.
53 is admitted.
In this Facebook post, you actually also posted screenshots of our conversations, correct?
Yep.
Isn't it true you also posted conversation screenshots with Emberly's daycare at the time?
Yep.
Isn't it true that daycare requested that you actually take this Facebook post down due to confidentiality?
Yep.
You still felt it was appropriate to post about our personal problems and all the people involved on social media, correct?
Yep.
Okay. Do you recall informing me that you posted that to shame me publicly into giving you Emberly for the weekend?
Yep.
And you believe that that was appropriate behavior?
Yep.
And you would
More-
continue to do that, correct?
More appropriate than your behavior, and yes.
Objection, motion to strike, non-responsive.
Agreed.
Thank you. And I'm going to share screen plaintiff's proposed exhibit 55.
Okay.
Is this a post of yours on Facebook?
Yep.
And what is the date?
August 1st, 2021.
And can you read what you wrote?
Do not message Sarah.
Oh, I'm sorry. I'm sorry, I would move to admit this as plaintiff's exhibit 55 first.
Mr. Tilly,
No objection.
exhibit 55 is admitted. Thank you.
I'm sorry, go ahead, Mr. Santilli.
Do not message Sarah. She is psychotic beyond control. She told me to fuck off and not talk to her, and then 3 hours later calls in a welfare check because I'm trying to put our kid to bed and not responding to her after she told me to fuck off. Cassie Santilli, Sherry D. Graham, Donna Santilli, Lavity. If she messaged you, block her or ignore her.
And again, this is posted on your personal Facebook page regarding me, correct?
Yep.
And again, you believe that this is appropriate behavior?
Yep.
I'm gonna go ahead and sorry, my computer is running slow. I'm going to share screen, proposed exhibit 56.
Yep.
Can you see these messages?
Yep.
Are these Facebook messages between you and Miss Carrie? Is it Vipperman?
Yep.
Did you write the messages that are in blue?
Yes.
I would move to admit proposed exhibit 56.
Who's Carrie Pipperman?
A girl I was talking to. A friend. These are private messages, by the way, between me and somebody else. They're not public. And she got these messages because she was logged into my Facebook account for 2.5 years, reading my private messages between me and other people.
Yeah, I'm going to object, I guess, on that basis. There apparently was a illegal hacking of his account.
Your Honor, I did not illegally hack anything. And in fact, Mr. Santilli's Facebook was logged in from the time that we were dating. I didn't even know that it was logged in for, I think I found out earlier this year. I did not know. I did not.
Maybe I can help here. You all may have to sort that part out, but I am concerned about the conversation between two people. I mean, anything that this other person said would be hearsay.
Yeah, and I'm not admitting the messages for her content. This is purely for what Mr. Santilli has said.
Well,
like her responses are neither here nor there.
Understood. In this format, I'm not gonna admit it. If you redact it or something and come back, I'll allow you all to address it.
Well, I also want to make a record. I just want to make the record clear that Mr. Santilli reported me to the police for illegal hacking. That went nowhere. I was not charged. I was not charged with a crime. I should get an opportunity to respond to your claims that I illegally hacked him, and I did not. And that was investigated.
I object to the testimony, Your Honor. She's now testifying to many facts.
You are accusing me of a crime.
I think that what she's doing is responding to an allegation, and what I'm telling you both, I'm not taking down.
I'm happy to redact those.
But the other, if you redact it and we have that issue come up, I'm not making a ruling right now as to whether or not it was legally or illegally obtained. If we go into those grounds, obviously we're going to need some more evidence than just us all arguing. So we need to consider that's why I was saying you all need to figure that part out. And it sounds like you may or may not have outside of this court hearing. It's because if we're going to push it, I agree. If we're going to push that as an exhibit, or if you're wanting that in, I'm gonna have to address the objection to because the way they're obtained to an extent, I think addresses the authenticity of it. I may have butchered that word, but that if I spelled it, you'd know which word I was saying. So if we'd have to verify it, is what I'm saying. And
Well, Mr.
the
Santilli
objection
admitted
on
he
the
wrote
table is that the objection, part of the objection. So here's my part of this. One, in the format, I believe it's hearsay, and I don't want that format in. I'm giving you an opportunity to redact it. That's what I'm telling you. If you redact it, we'll be able to argue about it again. Okay. Or I should say it this way. Maybe we won't have to argue about it. You'll be given an opportunity to request that it be admitted again, is what I'm saying. So this isn't just the decision on this forever. You can bring this back up. What I'm relaying though is if we're having concerns about how this evidence was obtained, it sounds like we're going to have an evidentiary hearing just on that part. So think about if that's something you want to do in this custody case, because I'll do it if that's what we're doing. But I suspect I'll likely ask people to brief a motion in limine and try to handle it from that point of view. Because if it's true what you're alleging, or if both of you on both of your statements, I think it's likely we'd have to have some sort of evidentiary hearing one way or another for me to have any idea how to decide that issue. So that's where we're at.
Is it okay if I ask?
Oh, sorry.
Okay.
Yeah. And I was gonna, let you do that. Let me go off the record for a second. I have someone in the waiting room, and I believe, I know that she's here for a hearing, but not for a hearing. Okay. We're back on the record on case number 2110643DS. Ms. Boyd, you're welcome to continue with questions, please.
Thank you, Your Honor. I'm going to go ahead and share plaintiff's proposed exhibit 32.
Thanks.
And Mr. Santilli, can you see my screen okay?
Yep.
And can you state what this appears to be?
Conversation between me and you using our family wizard.
And just for clarification with the court, this is actually, as it states here, this is the entire message report. So this is all of the Our Family Wizard messages. You can see starting when we began using the app. Mr. Santilli, can you read the date of this first message here?
6/19/2021.
Does that sound about right as to the date that we started using Our Family Wizard?
I guess. I don't remember.
And then it looks or it appears as though, can you state the date and time highlighted here?
5/07/2022 at 9:07 p.m.
Did we stop using Our Family Wizard for communication approximately in May of 2022?
Sure. I don't recall, but I know we didn't go past a year, so.
And why do you say that?
Because it was a 1-year subscription that neither of us renewed.
I would move to admit plaintiff's proposed exhibit 32.
Mr. Tilly?
Yes, I have no objection. It looks like this is verifiable, Your Honor.
Thank you. Exhibit 32 is admitted.
So I just want to highlight some of these messages. Obviously, there's a significant amount of them, but I think importantly, can you read your message highlighted here?
Shut the fuck up. Maybe I'd respond to your bullshit if you didn't fucking send me a goddamn message every 20 fucking minutes. Leave me the fuck alone. I swear to God, one more text this entire weekend and I will call in front of the court and see how I go about getting a restraining order on you to make you leave me alone.
And what was the date of that message?
7/9/2021.
And that was actually before you made that journal entry that was previously admitted, correct?
Yes.
And then sorry, there's a significant number of these that end up getting repeated because it includes all responses, so I apologize.
We're still on exhibit 40 or 32? This is 32, right?
Yes. Um, regarding the journal entries, you stated you didn't recall whether or not we had agreed to do those. Is that correct?
Correct.
Can you read your message here on 7/9?
Your thing is in the way on the
Oh,
left.
at the top.
No, I'm saying you do not need to ask me how M did every time I don't make a journal entry as soon as you want. I will make it when I can. And what question did I ask you? Can you leave me the fuck alone? Oh, wait,
Oh, sorry.
I asked rhetorical questions because the answer didn't really mean a goddamn thing.
So that was again talking about the journal entry, correct?
Yep.
What page is this, if I may? I'm sorry. What page?
162-ish.
Okay.
And then can you read this message on that same date?
I'm busy fucking working. I'm not refusing to do shit. Now stop being stupid and shut up. I do not need to tell you a play-by-play of Emmy's life while she's not with you at your whim. I have a life. I work. Sometimes it's infinitely more important than what our kid ate for lunch.
What date is that, please?
7/9/21. Then, sorry, I'm gonna just trying to highlight a few of these. essentially from the time that you moved out, you have not wanted to share information.
I've not wanted to share every little piece of information.
Did you take Emberly to the emergency room in the summer of 2022?
I remember taking her to the emergency room. I don't recall when it was.
Did you inform me at the time you took her to the emergency room that you did so?
Nope.
And you plan on continuing to refuse to share that kind of information with me, correct?
It depends.
Your testimony previously was that you were going to continue to refuse to share that information with me. Has that answer changed?
It depends on the situation. Every situation is different.
You understand that we share joint legal custody currently, correct?
Yes.
And you obviously are aware that our court order requires us to share that information, correct?
Yes.
Yet you're still stating that you will decide whether or not you do follow the court order and share that, correct?
It's not up to me to decide, but what I mean by it depends on the situation is, like, during that circumstance where she hurt her fingers, she was crying uncontrollably. She was very sad. She was hurt, and I was attending to her needs. And I thought that her needs were more important than letting you aware of the situation.
So in the future, so at no point when you took her in to the emergency room, did you think that it would be important to inform me of that emergency?
Nope.
Even though she was asking for me?
Yep.
Did you refuse to pay child support in 2021?
Yep.
Your Honor, I guess I should point out, if you don't mind, that 2021, the last custody order, which was a consent stipulated custody order, was obviously November 30th, 2022. I haven't objected. I know there's a lot that came in 2021, but I think it's worth noting, at the end of this at least, that normally we'd be limited to the information, since November 30th. And the other thing is, I think this question is kind of irrelevant. The child support, I mean, that's not even before the court. The pleadings don't have anything to do with paying or not paying child support.
That's not true, Your Honor. Child support is before the court. I objected to the second order modifying child support.
I know that. I'm going to give you a chance to respond. I know that there's an objection to child support. So it not to mention, it's not just that, but there's also child support. A court can consider child support issues with regard to the best interest factors. I mean, several of them concern caring for the minor. I mean, certainly I would say C does. But Mr. Tilley, you can finish, and then Mrs. Boyd, I'll let you continue. Or respond, sorry.
Well, that's my objection. To me, the pleadings don't raise child support. And maybe I'm wrong. Maybe somewhere in there's some mention of child support. I'm not saying there are no issues, I guess, out there. I'm just saying, as far as this custody hearing is going, I didn't think child support was an issue. I'm looking at her motion that she filed in January that was based. I call it a custody motion. It certainly was a custody motion, but it's grounded on a fraud, a statutory contract fraud argument, we filed our own motion and she answered it. So, certainly, custody is before the court. And this is a custody hearing. I get it. I'm just saying that, if we go down a long road about child support, I don't know. To me, it's tangential at best. That's all.
So let me say this, and then I'll let, I promised Ms. Boyd I'd give her an opportunity to respond, but let me just say this. And then she can put her statement on the record. We all child-related issues are on the table, from my understanding. We don't have an RRO. There was never an evidentiary hearing on any of these issues where someone in the court has made an ultimate decision as to custody, parenting time, and child support. So my understanding is what will come out of this is a referee recommendation and order, which would, an RRO. And then, of course, you can object and the judge will handle it that way as well. But my understanding is that for the most part, I'll say this, because the parties haven't really, there's not a total agreement on everything here. The court's going to have to decide everything. I believe that child support is a part of that, because certainly, if my understanding of what the parties want is true, which is they both want sole legal and they both want primary physical, that's different than what's going on now in their case. And a decision on that, depending on which way it goes, could affect child support. So all of these things are related. That's sort of my version on it. I would say it's quite common for custody and parenting time issues where people don't bring in their income or their pay stubs or anything like that. And so when I decide or recommend a decision to a judge, the way referees do, it's pretty common to refer to the front of the court. Front of the court takes the decision, and then they recommend child support, and then the parties can object to that. So I don't know whether you all are planning to bring in pay stubs and have overnights and all that figured in to what this case is. I can tell you that 90% of the time, no one does. So that's why I handle those cases that way. It's very rare for me to be to do from an RRO to just on parenting time and custody issues for me to determine the exact amount of child support. If that's what you're saying, I would agree. But I don't know that that's what you're saying. I think that child support is on the table. And I've already stated that I believe that child support payments or whether it's ordered or whatever it is we're getting into here is relevant to the best interest factors. So Ms. Boyd, you're welcome to respond to the objection, but those are my feelings on the issue as raised. Because I'll consider what you have to say too, Ms. Boyd. If you say, well, we've agreed to limit the issues to this or whatever. I don't know. That hasn't been relayed to me.
No, I don't think there's any agreement like that.
So we can continue.
Okay, thank you. Mr. Santilli, can you read off the message here at the top of my screen, the date and time?
October 15th, 2021, 7:41 p.m. Shut the fuck up, you dumb cunt. Don't try and fucking lecture me when you haven't let me see my kid for 3 fucking weeks. What's the point of setting rules and times when you don't follow anything but your own damn schedule? Piss the fuck off, you stupid bitch.
And at one point in these messages, do you recall telling me that you never wanted to see our daughter again and never wanted anything to do with her?
In those messages?
Yes. In our family wizard messages.
At an earlier time than October, yes.
21.
Well, here, actually, if you can read this for me that's highlighted?
Because when you make a mistake, you deny it and try and make me look like a piece of shit. Just fuck off and leave me alone, Sarah. I don't want my fucking kid. Don't expect a single dollar from me in child support. Don't expect another fucking word from me or to you or my kid. I'm deleting this app. I want nothing to do with you or my kid because my kid involves you. Fuck you.
And then I asked you if you were canceling her appointment with Christy early on for Friday morning, and what was your response?
Yes, I will cancel it all.
And did you in fact cancel it?
I don't recall.
Can you read this message for me that's highlighted?
Fuck you and die, you fucking cunt.
And earlier your testimony was that that wasn't normal language that you would use with me, but I've highlighted a few instances where you have used that.
That have all been from 1 to 2 years ago. This is back in 2021.
Would you like more recent examples?
Yes, please.
Well, if that's a,
I mean, I have all of our text messages, Your
I'm
Honor.
just,
I wasn't trying to be argumentative.
you can provide, if you want to go over it with him, you can, but I'm guessing you're not wanting to have him approve every single thing that you do, correct? You understand what I'm getting at, I think.
Yeah,
You're
moving
welcome to
forward,
show
I
him-
won't be asking. Yeah,
I'm
moving
sorry.
forward, I won't be asking his permission as to what I do next. Actually, before we move on from our family wizard, I'm going to share screen proposed exhibit 45.
Okay, thanks.
Kyle, can you read the date at the top of this message?
By the way, this says exhibit 38. Did you say exhibit 45? Looks like,
No, I said it.
oh, I'm sorry,
Exhibit
you're right.
40.
Forget it. I get it. Go ahead.
Wait, I do need clarity because I thought you did say exhibit 45.
I did, and this is exhibit 45.
Oh,
It was a tab. I was just looking at a different tab.
oh, okay. All right. So we're all on the same page.
Yes.
Thank you.
Can you go ahead and read the date?
12/4/2021.
And can you state what this is?
A message from me to
Through-
you.
Through our family wizard,
Yeah.
correct? I would move to admit exhibit 45.
Mr. Tilly?
Except for relevance, I have no objection.
I'm confused. I thought you submitted all of our family wizard messages anyway.
I have the same, I have a simpler question because I thought that's what 32 was.
Right.
They are. This one was just pulled out specifically regarding child support. So I guess if you want me to go back and reference that one, that's fine.
There's less
Yeah.
clutter. It might be a good idea.
Yeah, I think we'll go ahead and do that.
Okay.
But that means you can bring it up on the other exhibit and talk. Okay, all right.
Yeah.
What
It's
was
just
the
such a large file.
Understood. You're welcome to share screen. I just had to type that in.
what
Yeah,
date is
sorry.
it?
I'm
While you're doing that, what is the date?
the date of the message
Yes.
was December 11th, 2021. Oh, wait. I'm sorry. It was actually December 4th. Okay. So this is page 1234 of Exhibit 32. Can you read the date and time of this message?
12/4/2021, 10:02 p.m.
And what message did you send?
No, I will not reimburse you. I have your child support, and if the court orders me to pay it Wednesday, essay, I'll pay it Wednesday.
And that was because you had refused to pay child support for quite a few months, correct?
For 3 months, I believe, yes.
And you also refused to pay child support in 2022 for, I think it was 5 months, correct?
No, well, that would have been 3 months one time and 1 month another time.
You refused in 2022 to pay child support in July, August, September, October, and November, correct?
I believe it was only 4 months, not 5 months.
And isn't it true you were actually held in contempt for refusing to pay child support when you had the ability to pay?
Yes,
Do you believe it's appropriate to withhold financial resources from your daughter?
I guess that's a loaded question. Do I believe it's appropriate? No. Do I believe in my reasoning of why I was doing what I was doing? Yes.
So essentially, though, isn't it true you were trying to use child support to punish me?
No.
You had the ability to pay, though, correct?
Yes.
And you just refused to, correct?
Yes.
So your reasoning for withholding child support was for the purpose of trying to get me to comply with your requests, correct?
No. Well, I guess since there were different times, one time, yes. One time I was withholding my child support to try to get you to let me see my kids since I went 2.5 months without seeing her. And then the other time it was because we came to an agreement in mediation that I thought would change the child support and did not understand how any of that worked. So
So isn't it true, really, the only reason you wanted additional time or overnights was due to the modification of child support?
no.
In fact, at one point, I even offered you limited additional parenting time every other Friday with our daughter, but you refused and stated that I would actually have to pay you daycare costs, or you wanted credit through child support. Do you recall that?
Yes.
Is this December 2021 or?
No, this is, I believe it was February of 2022.
Okay.
You refuse to currently modify the exchange from Sunday morning to Saturday evening due to wanting credit for child support, correct?
No.
Even though you admitted to me that you believed it was best for Emberly if the exchanges happen in the evening on Saturdays, you still refused to modify the order, correct?
Correct.
And that was due to the fact that you would lose and end up having to pay child support. You would lose overnights and have to pay child support was your concern, correct?
No.
So if you agree and I agree that the modification to move the exchange to Saturday night is best for our daughter, your refusal is based upon what?
I lose on time with my daughter on a night.
Even though it would be best for her if the exchange happened in the evening.
So the way you're wording it, you're saying that you want me to accept less than 50-50 because you want to subtract time, whereas if the sole intention of exchanging our daughter in the evening best suits our daughter, why not make it Sunday evening at 5 o'clock instead of Saturday night at 5 o'clock?
Why not make it Friday night at 5 o'clock?
I would love to do Friday night at 5 o'clock.
So your only concern
off.
really is that you get 182.5 overnights, not necessarily what's best for Emberly, correct?
I believe that the two things align, that our daughter's best interest is that she sees her father more.
So the only thing you would find acceptable is if you get 182.5 overnights, correct?
I don't give a shit about the overnights, but I'm not gonna like, how do you have 102 and a half overnights? You can't have half an overnight. Like, this is just stupid.
Well, your concern appears to be based on you not getting what you want, which is 50-50, correct?
Which is my daughter, yes.
So 50-50, when you calculate child support, is 182.5 overnights, as it currently states in our current child support order. My questions are based upon that.
If you're concerned about the times, how about you give me 75-25 and you can decide the times all you want? Like, I don't care about specifics. I just want my daughter. I want my daughter more than 182 and a half nights out of the year. But, people keep saying 50-50 is the best thing, but you can try to spin this however you want. Like, I'm voicing my objection to your misleading questions. Like, this is just, you're trying to make this about money, and it's never been about money to me.
Then why did you withhold child support?
Because you weren't letting me see my daughter.
Asked and answered.
Then why did you refuse to pay half of daycare costs for this past summer and reimburse me for half of her schooling supplies? I had to file a show cause, correct?
Correct.
If it wasn't about money, why wouldn't you just reimburse me normally?
Because you make these decisions without even informing me. I didn't want our daughter to go to the Leelanau daycare summer program school. I wanted her to go somewhere else. And I would have liked to have had our aunt, or my aunt Dawn, watch her so that she could have spent the days with her cousins rather than random people that she doesn't even play with outside of school.
But that's actually more important to you than anything else, correct? Is that our daughter spends more time with your family and her cousins than anything else.
Specifically with her cousins, because that's all she asks about. Yes, she absolutely loves her cousins, and if anybody were to witness her, you would easily be able to tell that that is her greatest interest, is playing with her cousins all the time.
And actually, that's your only interest in wanting to move schools, is to move her to where her cousins go, correct?
And logistics, but if that's what you say.
So it doesn't matter the kind of education she would receive or the facility she would be at. Your concern is based on her being able to be with her cousins, correct?
No, because the facility, it's a 5-star versus a 4-star. Like, you're trying to make it sound like you're comparing like high education to like going to the slums where they don't even care if you go to school every day or not. And if you want to bring up education, you haven't even taken our daughter to school in the last 6 weeks, and you kept her out of school for like.
Objection, strike is non-responsive.
No, it's not the only reason.
I mean, if you're waiting for me to rule, I would say that he's answered some of the question. His attorney can follow up with the other parts if there are issues with.
So was the other part stricken?
Yeah, but
Okay.
that wasn't a yes or no question, and I mean his answer was overall permissible. It was just bringing up an education issue with you, which he'll have an opportunity to present that evidence later. That wasn't so yes, that was non-responsive to your question, but most of it was responsive.
And my concern is also he's bringing in hearsay as well about attendance. There's been no information given about that.
Well, that's the part you're talking about when he said you haven't taken the
Yes.
child to school. Well, yeah, that's the part I am not
Okay.
considering because it didn't answer the question.
Okay. Thank
But
you.
his other answers, he gave a full answer.
Yeah.
That was beyond the one that anyway, that's
You never proposed using your Aunt Dawn to me for childcare for the summer, correct?
Correct. Well, can you be more specific on which summer?
This past summer.
Correct.
So you had an alternative that you wanted to propose. You disagreed with my proposal, but refused to present your alternative, correct?
I presented you with alternatives, but you didn't respond to them. So
What alternatives did you present me with?
the YMCA.
Actually, I think your testimony from June and July contradicts that. We had the same issue in front of Judge Kromkowski. You tried saying that you proposed the YMCA, and actually you never did.
I did.
I don't know that I don't know that you're wanting to argue with him about what's factually correct.
I'm asking if I should bring up the transcript to show him his testimony regarding that issue.
You're asking him if he'd like to see the transcript?
Right, to refresh his memory about that issue.
That's fine if you're at, yeah. But I just don't want you arguing with him about
No, I
what you're
understand.
saying is fact. That's all, it's format. But you are welcome to bring up the transcript if that's what you're asking me. Sorry. So I'm trying to figure out who you're asking.
Mr. Santilli, would you like to refresh your memory by reviewing the transcript regarding your prior testimony?
Yes.
Oh, just 1 second here. I'm going to find.
Are you gonna post this or screen share?
Yes, as soon as I find the part that's relevant, unless you would like to watch me just scroll through the transcripts.
It's okay, yeah, just asking. Because I could look for it myself, that's all.
I believe I found. This is talking about the school.
Which hearing?
Actually, so I think it's June 14th. I'm gonna go ahead and share plaintiff's proposed exhibit 2.
1 second. Let me just put on the marker. Thanks.
I don't think I have the June 14th transcript. By the way,
It's on the flash drive.
okay. So as an exhibit or?
Yes. So starting here.
Let's just
Well, I guess.
just 1 second while you're looking for it. Is there an objection to admitting this transcript, Mr. Tilly?
Um, again, I mean, it would only be relevance. So I guess not, Your Honor, for this purpose.
And you wanted this admitted, correct, Ms. Boyd?
June
Yes.
14th? You said the June
Yes.
14th?
So for the record, Exhibit 2 is admitted. Now you can read from it.
Thank you. Mr. Santilli, this is you testifying as to the answers discussing the summer of fun. It
Yep.
states, tell me about this
You have a page number?
30.
Thank you.
Do you recall this?
Yeah.
And your response was that I gave you 2 weeks to get Emberly a spot somewhere, correct?
Yeah.
And actually, the court asks you about the summer of fun and other providers. You stated you said the Traverse City YMCA Development Center, correct?
Yep.
And then we go through. And I believe the court gave us an opportunity to take a break to see if we could find any communication regarding the YMCA for that specific purpose of the summer of 2022. And actually, there wasn't any communication. Do you recall that?
I was unable to find it. And I believe that what I was asked is if I was able to give you specifics about the YMCA Developmental Center, including hours of operations and costs of how much it would be.
No, you say, so the court says right here, so after you're just saying 2-3 months ago, you gave this option to Miss Boyd to consider. Did she provide any answer? If so, what was her response, if you recall?
Okay. And then my response was, so scroll up a little bit. Do you want me to read my answer out?
Well, what answer are you referring to here?
Yeah, scroll up so I can start from the beginning. And I'll read it. I believe before the 2 weeks was up, she was demanding that I haven't given her any names yet and that it was out. We were out of time and we needed to respond to enroll her or choose whatever daycare or whatever. And so then I meant the YMCA and that I wanted her to go somewhere closer to town so that would be an easier drive for all parties involved.
Right, and then the court asks if you can recall if I provided a specific response, correct?
Yes.
And then further down, I then ask you, isn't it true we actually discussed it for a childcare option prior to that, not as an option for this coming summer? And you said you discussed it a couple of times and we kind of go back and forth, part of the Summer of Fun program. Then we get into some first right of refusal stuff. And I believe that the court eventually allows us to take a break. And we end up going back on the record. And you weren't able to find any messages regarding that.
Correct.
Because you didn't actually offer it as an option for the summer of 2023, correct?
I just want to go on record saying that next Thursday when we resume this, I will bring in the text message discussing the YMCA Developmental Center as being an option for 2023.
Well, you weren't able.
I had like 15 minutes to find it.
Well, so the question is, did you actually offer that as an example? So you can, or as an option. So you can answer that question first because that has been asked.
Yes, I did.
All right. So Ms. Boyd, you can continue asking. I just wanted an answer to that question.
But your testimony is that you did offer me that YMCA is an option for childcare.
Yes.
And actually, it's right here. It says that we're going to double check. Did you see any YMCA texts? I stated I did and didn't see anything. And Mr. Tilley indicated that the YMCA was probably brought up, that there was mention in the deposition. It was probably brought up at one point for childcare in 2021 and 2022, not regarding the summer of 2023.
Okay, well, all I know is that I did. I had 15 minutes to find the text messages. If you'd like me to find the text messages before next Thursday, I absolutely will. Because as you've been scrolling, I also read how I mentioned that it would be closer and how you claimed that it wasn't closer and everything. And I know we had a conversation about it, so.
Again, this conversation I'm specifically talking about, as far as any discussion of the YMCA, didn't happen regarding where to place her for 2023, though, correct?
And I'm telling you that it did happen about placing her in 2023. So the only, like, I don't know what you want to do here, but if you want me to find those text messages in the next week, I will gladly bring them and have them available for next Thursday.
So you refused to pay for half of childcare costs because you stated that you informed me about the YMCA and didn't want her to attend Summer of Fun, correct?
Correct.
Nonetheless, we're court ordered to pay for half of the childcare costs, correct?
Correct.
So no matter where she went, you would have been required to pay half of the childcare costs, correct?
Correct.
So it didn't really matter either way, childcare had to be paid for, correct?
Actually, that's not correct, because if I remember, there was no Friday on the Summer of Fun, and because the daycare didn't go 50-50, I only had to pay 1/3 of the daycare costs. And that's what the
still responsible for payment of childcare costs, correct?
Some of it, yes.
Did you ever ask me or represent me that your concern was that you were paying for childcare that didn't cover a day in which you would have had Emberly?
Can you repeat the question?
With the Summer of Fun program, let me clarify. With the Summer of Fun program, your concern regarding you paying half the childcare costs, but them not covering the full 5 days and you paying for a day in which you don't actually have available to you because you have every Friday. Did you ever bring that to my attention?
No.
You just flat out refused to communicate, correct?
I believe I was communicating with you.
You refused to communicate about that issue, correct?
Incorrect.
It's asked and answered.
He's not answering.
I just said incorrect.
He did answer. I think you don't.
So
like
are
the
you
answer.
saying that you did communicate with me your concerns about the number of days and the payment required for the Summer of Fun program?
No, I communicated with you about the Summer of Fun program.
Did you tell me that the reason why you didn't want her to go there was because of the payment issue and the number of days covered?
No.
So how was I supposed to know that that's your concern?
That wasn't my concern. My concern was I didn't want her to go to the Summer of Fun program because it was too far away.
She hates
That's
how
where
long
she
of a-
goes to school though, correct?
only because you bullied me into it, and I didn't know that I needed to object to it back in 2021 or
Objection, strike
2022.
is non-responsive. The question is that where she goes to school?
Yes,
Okay.
against my will.
Did you not message me in 2021 and tell me that it was okay for Emberly to be enrolled at the Leelanau Montessori?
After being forced to by my lawyer, yes.
You're telling me that your lawyer placed you under duress to send that message to me?
Yes.
All right, on that note, we're done for today.